Welcome to Court TV on Crestview Community TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today you're watching Docket Day. Now, Docket Day, last year and in previous years, it was the biggest court date. Now we've added a court date with pretrial conference happening the week before Docket Day, so Docket Day has shrunk down and gotten somewhat smaller. However, you're still going to see defendants who maybe have been in court for the first time, maybe their appearance was waived at pretrial conference, which we spoke about in that video. But when someone's called to the podium, you're going to see, again, one of a few things can happen. They can enter a plea. At that point, the case will be over, and they'll get sentenced either today, live on Crestview Community TV, or they'll get sentenced in a sentencing hearing down the road on one of those miscellaneous dates that we'll talk about in another video. They could also ask to continue the case. At that point, it would get set to another cycle 6 weeks down the road. The last thing they could do is they could announce ready for trial. And that means, hey, we're ready, when we're going to send this case to a court date called jury review. And then from that point, the case will get sent to a jury trial. And I know that's what we all really, really love to see. Those obviously are rare. They don't happen a lot. But we all get excited when we hear that, ready for trial.
I would
November 27th.
That's next Monday. I would ask, Your Honor, I would ask for the latest date in December that I
December 4th, I think. Oh, well, no, I've got other dates. I've got December 11th, 14th, 18th.
I would want 18th, Your Honor, just because we are about to start the trial cycle and everything.
So, Mr. Mills, we're going to continue your underlying case until January 8th, but we're going to set it for a status conference on December 18th with the understanding that the state will subpoena those witnesses. If they don't appear, hopefully we'll have a resolution.
Thank you so much, Your Honor.
So it's December 18th at 9 o'clock.
Thank you, Judge. I appreciate it.
Thank you, sir.
Judge, the next case I have on the docket is Darren Michael Plate, 23 CF 348. As the court's aware, Mr. Plate has some significant health issues. The court graciously allowed him to waive his appearance today. The state has made an offer this morning that I need to relay to Mr. Plate, and I anticipate it could resolve.
Okay, so it's continued one cycle.
Thank you, Judge. Next case I have is Charles Andrew Shropshire.
Mr. Shropshire, how are you? Good morning, sir.
Good morning, sir. How are you?
Good, how are you?
Good, thank you.
23 CF 2014, Judge. We left this on in hopes of resolution as well. The state, I believe, is in possession. This is Mr. Snell's case. I'm not sure. Oh, there. The state is in possession of a drop charge form. I think the state wanted to put it on for Wednesday so they can make contact with the alleged victim. I'm going to be out of town. I don't mind leaving it on for status so that Mr. Snell could tell the court it's going to be no price or not at that time if the court will waive our appearance because I'm going to be gone. But
Mr. Snell?
That'd be ideal. Mr. Flowers won't be here as well, correct?
yeah.
He's right behind you.
Yes, sir.
Are you going to be here? Could you be here Wednesday?
Yes.
Okay. Then we'll put it on for Wednesday, Judge.
Okay. So the underlying case is going to be continued until January 8th at 9 o'clock, but we'll put it down for a status on Wednesday. So you don't have to be present Wednesday at 9 o'clock, but Mr. Flowers will be here for you.
Yes, Your Honor.
Thank you, sir.
Thank you.
Thank you, Judge.
Thank you. Teresa, what cases do you have?
Good morning, Your Honor. I'm here to assist Mr. Powell
Okay.
on Moroyoki.
Okay. Is Mr. Powell present? Okay. Whenever you see him, if you'll grab him and let me know.
Yes, sir.
Thank you.
Next case, Judge, I have is J. Sucom, S-U-K-O-M. Judge?
Yes, sir. Good morning.
Good morning, sir. Judge, before the court is Juthatype Sucom, 22 CF 1931. At this time, Mr. Sucom would withdraw his previously entered plea of not guilty, tender a plea of no contest to the amended charge on count 1 of unlawful use of a two-way device. Counts 2, 3, and 4 would be no priced by the state. Count 5, which is same as count 1, unlawful use of a two-way device. There'll be a withholding of adjudication of guilt, 5 years probation on counts 1 and counts 5, which are consecutive for a total of 10 years. Sex offender evaluation and any treatment recommended. This is not sex offender count or sex offender probation. It's just an eval and any treatment recommended. No unsupervised contact with minors during the course of probation. Forfeit the device that was seized, and there's the state and the defense stipulate that no registration is required. There'll be fines and court costs required by statute or ordinance. May I approach, Judge?
Yes, sir. Thank you. Mr. Sucom, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand out. Mr. Sucom, are you currently, well, have you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Sucom, I do accept your plea. Counts 2, 3, and 4 are dismissed. On counts 1 and 5, adjudication is withheld. You're sentenced to 5 years probation, and that's consecutive for a total of 10 years of probation. You'll need to submit to a sex offender evaluation. Usually I say within 30 days. I'll still say within 45 days since it's the holidays. If any treatment's recommended, then you need to start that treatment within 75 days of today, okay? You have no unsupervised conduct with any minors. The subject equipment is forfeited. You need to pay the court cost. You also need to pay the $40 per month cost of supervision. Anything that I've missed for Mr. Sucom?
No, Your Honor, but for the clerk's information, count 1 would be amended LIO to unlawful use of a two-way device. That's Florida Statute 934.215.
Thank you, Mr. Sucom.
Thank you, Judge.
Thank you, Mr. Shaw. Mr. Flowers. Morning, sir.
Yes, good morning, Judge. Judge, the matter I have before you is Overland. And Judge, we were sent an agreement, a pretrial intervention in agreement. What would the court expect if we could set that for control date so we could have her come in, sign it, and then forward it to the court? I think that's what the state anticipated also.
That's correct, Your Honor. We have come to a PTA agreement on this case.
Okay, good. So we'll just continue it until January 8th at 9.
Thank you, Judge.
Thanks, Mr. Flowers. Ms. Merrifield.
Judge, if I could have just another moment.
Yes, ma'am. Let me know when you're ready.
Thank you.
See Mr. Sellers drifting around? Okay, thank you. Ms. Dudley. Hello, Ms. Dudley. Good morning, ma'am.
The first case I have is Johannes Radma. We had left this set to see if the state and I can talk about it. Mr. Snell still needs to talk to the victim in this case, so we just ask for continuance.
Okay, it's continued.
Is that January 8th?
Yes,
I
ma'am,
believe.
at 9, correct.
The next case I have is Andrew Scott. The state and I have talked about this one. We're going to leave it set for continue to the January 8th date, and hopefully we can have it worked out before then. That's our goal anyway.
Yes, ma'am, it's continued.
The last case I have is Quayshawn Toomer in 22 CF 2110. I do have a plea to a misdemeanor, Your Honor. If I may approach?
Please. Hello, Mr. Toomer.
Hey,
How are you
morning.
doing? Good
Good.
morning, sir. Good to see you,
good to see you too.
especially with a plea agreement in my hand. Let's see what it says. So, Mr. Toomer, the plea agreement says,
We will plead to a lesser included possession of paraphernalia
good,
in count 1, 893.147 is the statute's first degree misdemeanor. The state will dismiss count 2, adjudication of guilt, 270, court costs payable within 90 days.
and it's time served.
Yes, sir.
Mr. Toomer, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Toomer, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
You haven't signed it.
Oh.
If you agree to it, if you'll sign it.
Yes,
Yes, ma'am. Thank you. Mr. Toomer, have you signed the plea agreement?
Yes, sir.
Mr. Toomer, you're adjudicated guilty of the misdemeanor. You're sentenced to credit for time served. The court does impose the court cost. If you fail to pay those within 90 days from today, then they will go to a civil lien or judgment. And I think that's it, Mr. Toomer. Thank you,
Yes,
sir.
sir.
Good
Thank
luck to
you.
you.
Your Honor, I believe that's all I have. Thank you.
Thanks, Ms. Dudley. Mr. Gates. Morning, sir.
Judge, how are you?
Good, how are you?
Fine, thank you. Your Honor, before the court is Guy Santucci. Mr. Santucci is about to enter into the PTI program, we believe, but Mr. Snell has one other person to authorize that, and if we could pass this to Wednesday so he can confirm that, we'll be back on Wednesday morning at 9.
Mr. Snow?
Perfect.
So, Mr. Santucci, there you go. I'll see you on Wednesday at 9 o'clock. What I've got from doing my homework from last week was, we were going to trial, so it's quite a jump to go from trial to a pretrial intervention. I hope that they accept you in that, and I'll see you on Wednesday, okay?
Thank you.
Thank you, sir.
Thank you,
sir.
8:45
Okay.
Okay.
Meet you right here.
Here, right here.
Outside the door. Thank you.
Your Honor, the next case I have is Thomas Lowry. Mr. Lowry? Your Honor, last Monday, the court had directed Mr. Lowry to be here, and we had a conversation after court. He's unable to pay attorney fees in this case, and I filed a motion to withdraw. He's signed it on the 15th. We filed it on the 15th. And right after that, Mr. Lowry got the application for the Public Defender's Office. He's completed it. He's not filed it yet. He was told he could do
If I
that
could
this
have it,
morning.
That'd be great. Mr. Lowry, so do you, please. Mr. Lowry, so do you object to Mr. Gates withdrawing as your attorney in this case?
No, sir.
Okay. So, Mr. Gates, do you have any other cases?
I do not.
Thank you. Thank you, sir.
Thank you.
Your motion's granted.
Thanks. No, say, he's gonna. he's
So,
gonna
Mr.
make a public defender, okay? So if you-
Mr. Lowry, in your application, it doesn't say how much money you make per month. How much do you average making?
Roughly 800 to 1,400 a week.
Okay. A week? Okay. you're not going to qualify probably for the public defender making that amount. I mean, it's not really close.
I just got my job back maybe last week, so.
Yes, sir.
I don't know, just trying to catch up.
If you're making even $800 a week, you're not going to qualify. If you want to fill that in, $800 or whatever dollars per week, and then I'll hand it to Madam Clerk. But the clerk's going to look at it and probably say you don't qualify. Even if you appeal it to the judge, at the bottom you can say, hey, I want the judge to look at this. We have more latitude. But again, I don't see you qualifying. There's a $50 application fee if you want me to submit that. Otherwise, you'll either be representing yourself or you'll need to hire another private attorney.
Okay.
Okay, do you want to fill that in? Please, if you will. Do you have a pen? Good. It's just right there at the top. Thank you, sir. Thank you. Mr. Lowry, I'm handing it to the clerk, and they'll look at that, and they'll notify you if you qualify. If you don't qualify, again, you'll either be representing yourself when you come back on January 8th at 9 o'clock, or you'll need to hire another private attorney or rehire Mr. Shaw if you can. Okay. Thank you, sir. I'll see you January 8th at 9 o'clock.
Yes, sir.
Thank you.
Judge?
Yes, sir.
I stepped out for just a second to talk with Mr. Black.
You did, Mr. Sellers, and I called your name. You ready?
Thank you, Judge. Yes, sir. We've worked this out, Judge, so we're finally, after all this time of being together, we're finally resolving this case.
And Mr. Sellers, I thought the same thing. When I came in to turn on the Zoom at a little after 8, well, before 8:30 this morning, a couple courtroom personnel were here, and I mentioned about your motion for bond, and they said, are you going to let him hear that? Are you going to hear that today? Because usually I don't hear those, and I said,
Right.
And I went through the scenario of Mr. Blackshear, and I said, yes, we're going to hear that today. Thank you, sir. Good, Mr. Blackshear. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You can put your hand down. So, Mr. Blackshear, did you read the plea agreement?
Sir, yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his
Yes, sir.
representation? Okay, wait for the whole question, okay? Did you sign the plea agreement?
Yes, sir.
Okay. I know you're anxious about it. Mr. Blackshear, I do accept your plea. Adjudication is withheld. You're sentenced to 2 years probation. You'll need to perform 24 hours of community service work. You'll need to pay the $615 in court costs. Your supervision, is it going to automatically terminate at 1 year, or you can petition for that?
Given what Mr. Blackshear has gone through, it would automatically terminate at 1 year, as long as he's completed all requirements and no new law violations have occurred.
So, Mr. Blackshear, your supervision, your 2 years of probation will automatically terminate at the 1 year mark if you've completed all the terms of your probation by that time and haven't committed any new law violations. You'll need to pay the $40 per month cost of supervision. Mr. Blackshear, how much money do you make per month?
I mean, I get a monthly check every month,
Okay, how much is that?
$750.
Okay. And I know you've been either in jail or at the Florida State Hospital before that. So how much money were you making before you got involved in the legal system?
The same amount.
Okay. I do waive the cost of supervision, okay? So you don't have to pay the $40 per month.
Thank you, Judge.
Okay? Anything else for Mr. Blackshear?
No, sir, Judge.
So, Mr. Blackshear, they'll let you out of jail today, okay? Thank you, sir. Happy Thanksgiving.
Thank you.
Yes, sir. Thank you, Mr. Sellers. You stuck with it. You drove over here. Thank you so much.
Thank you, Judge.
Yes, sir.
Sellers.
Sir?
Give this to my grandfather.
Yeah.
I'll talk to him. I'll talk to him.
Thank you so much.
Ms. Jaquith? I don't see her, so we'll go back to the top. Mr. Heath?
Good morning, Your Honor. May it please
Good morning,
the court.
sir.
First
Yes,
and
sir.
foremost, my apologies. I was bouncing between courtrooms this morning. So,
Yes, sir.
Your Honor, James Heath on behalf of Tammy Ann Rothacker. Ms. Rothacker should be approaching to my left. That's going to be case number 23 CF 1029.
Good morning, Your Honor.
Good morning, ma'am.
May we approach, Judge?
Yes, sir. People. Mr. Heath can set it for a hearing before that date, okay?
Yes, sir, thank you.
Thank you, ma'am. Good luck to you.
Thank you. Have a happy Thanksgiving.
Thank you, you too.
Judge, that's all I have. May be excused.
Yes, sir.
Have
Thanks,
a good
Mr.
Thanksgiving,
Heath.
Judge.
You too. Thank you. Mr. Garrett? Okay. Mr. Rare, Mr. LaPella, whoever wants to come first, or?
Good morning, Your Honor.
Good morning, Mr. Rare.
For the record, David Rare, co-counsel today with Mr. Lupella. First we have Judge is Mr. Gary Maxwell. Judge, in this case, we were set for trial. In speaking with the state, there are some scheduling issues and also the possibility of a resolution. There's a late added witness from the state we've not yet had the opportunity to depose. We would need to do that before we could proceed to trial. Scheduling-wise, my understanding is, the alleged victim is not available the second trial week. Mr. Lupella and I have conflicts the first trial week. But additionally, we received some new information from the state about a possibility to resolve the case. What now I believe the state will object. What we'd ask the court to allow is to continue this out. We're not necessarily asking for a full cycle continuance to the January pretrial. If the court has some miscellaneous date, maybe mid-December, I'd like to bring it back sooner rather than later and see if we can resolve it this year.
Okay, to the state.
That's correct, Your Honor. The victim is unavailable the second trial week. When we were going through and sending out all the subs, there was an officer that was not actually listed in the report that dealt with a photo identification. So we have no objection to this continuance. We have also relayed that there is a possibility for a misdemeanor agreement. And so we would be completely okay with maybe setting it off to like the 12/14 morning docket as a status to see if we can get it in for a resolution on that time, at that time.
Okay. Mr. Maxwell, I smile because we have continuing education as judges, and, they tell us, think before you speak. I mean, a lot of different things to not lose your cool. And out of about 10 video clips that I watched of judges losing their cool, 8 of those 10 were the judge trying to push time. And they'd say, nope, this is 2 times plea trial, you're going to trial. It doesn't make sense in this instance. If there was a little more time, maybe if it was going the second week of the criminal jury trial, I'd say, nope, y'all need to depose this new witness within the next week, and we're going to trial that next week. I can't do that. I mean, that's not justice. So I'm continuing your case until the pretrial conference on January 8th at 9 o'clock. I'm not going to set it for a status conference between now and then, but if there is a plea that you want to enter before that date, then your attorneys can schedule that with the clerk, okay? So I'll see you back here no later than January 8th at 9 o'clock.
Thank you.
Thank you, sir.
Thank you, Judge.
Thank you.
Next judge I've got is Joseph Rogers. Mr. Rogers is present and approaching, Your Honor. The court will recall the bond hearing we had last week. My understanding is Mr. Rogers' doctor was in surgery on Friday, so we did not have the opportunity to get the additional documentation the court requested of us. In speaking with the state also, they'd like to see that documentation and about the possibility of resolving the case, depending on that recommendation from the doctor. What we spoke about doing is continuing this out to January 8th, pretrial for status. If we can bring it back in December for an early plea or resolution, we've tried to do that certainly, but I believe December 4th is still he's scheduled for surgery and that biopsy, so we need the additional time for him to complete that.
To the state?
No objection.
Okay.
That's exactly the conversation we had.
Mr. Rogers, similar to the prior defendant, but I only have it down one time for plea or trial. So refresh my memory on what that, because, well, let me just talk to the state. Mr. Snell, so depending on what is obtained from the MD,
He has, I'm sorry, I interrupted you.
and I was not trying to publish his medical condition, but
He has some important dates scheduled with his doctor this month.
oh, gotcha. Okay.
And it's appropriate for those to take place before we resolve the case.
Gotcha. Okay, good. Mr. Rogers, I'll see you back here no later than January 8th at 9 o'clock. If you want to enter a plea before that date, your attorneys can schedule a hearing, okay? Thank you, sir.
Your Honor, Sean LaPella for the record. The last case we have from our firm is Cameron Searcy. As the court may recall, on Monday last week, I'd indicated to the court that there was we were going to file a motion to exclude. We wanted to set it for status today and file a motion to exclude to let the state be aware of the situation with their alleged victim witness. And I guess just to put the ball in their court as far as if they want to go forward with this or if they do have a viable witness or not. I don't know if the state has had enough time to evaluate whether or not they do have a viable witness. So I guess I would just defer to the state on that issue. And if they do, then I guess they'll be asking for a continuance to locate him and be able to produce him for a deposition, which we would schedule as soon as possible.
To the state?
Can we approach briefly?
Sir.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law for your...
These cases continued one cycle.
That's all we have, Your Honor. Thank you.
Thanks, y'all. Ms. Merrifield.
Good morning, Your Honor.
Good morning, ma'am.
So the first 2 cases I have is under Mr. Flaherty.
Okay.
The first one is James Mendez in 23 CF 568. Mr. Mendez is present and approaching. And Judge, we've reached an agreement, if I may approach.
Yes, ma'am. Good morning, Mr. Mendez.
Good morning.
Thank you, ma'am.
And in 23 CF 568, Mr. Mendez is withdrawing his previously entered plea of not guilty, entering a no contest plea. Count 1 is dismissed. He will be entering a plea to count 2, the solicitation. Would be 60 months of sex offender probation, $40 per month cost of supervision, $515 in court cost, 101 crimes against minors. He is required to have a GPS pursuant to Jessica Lunsford Act at $1 a day. Is to have no unsupervised contact with minors, not be in a place where minors congregate, and no electronic devices capable of internet access until after the completion of the risk assessment and sex offender evaluation and treatment. And Judge, we do contemplate his ability to apply for modification of the internet usage after he's completed that risk assessment to give the state the benefit of those results. He understands that he will be designated as a sexual offender to include all of the requirements per statute, and he is to be adjudicated.
Okay, thank you. And this is a negotiated plea, that's why it's a downward departure?
Correct.
That's correct, Your Honor.
Mr. Mendez, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Mendez, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
High school graduate.
Good. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he or she answer all of your questions?
Yes, sir.
Are you satisfied with the representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Mendez, let me ask you one question since it's written in here. How much money do you make per month? And the reason why I ask you that is they've started putting some heat on the judges, or at least suggesting strongly that the dollar per day, I think the county has to subsidize that GPS amount. And so I want to make sure before I accept the plea that really you should receive the minimum amount versus the traditional amount or the cost for that. How much money do you make per month?
Working for my wife, I think I'm averaging $2,000.
Okay. Okay. Mr. Mendez, I do accept your plea. Count 1 is dismissed. You're sentenced to 60 months sex offender probation in count 2. You'll need to pay the $40 per month cost of supervision. You need to pay the court cost, the $101 crimes against minor. You will need to wear the GPS for $1 a day. You'll have no unsupervised conduct with any minors, not be in a place where minors congregate, and have no electronic devices capable of internet access until after the completion of a risk assessment in the court's order. The court's order that says that you can have access to that. You may apply for the internet use for employment after completion of the risk assessment. You are designated as a sex offender, and you have all the statutory requirements of the sex offender. You're adjudicated guilty. Anything else from Mr. Mendez?
And Judge, that would be a downward departure based on a negotiated plea, and I know Ms. Merrifield had addressed this previously with her client, but any devices seized would also be forfeited.
Okay, yes, ma'am, those are forfeited. Thank you, Mr. Mendez.
Thank you, Judge.
Yes, ma'am.
The next case is Blake Sanford and 22 CF 3165. There was a waiver on file for Mr. Sanford, and as the court may recall, at pretrial, we set this for plea or continue. We are trying to finalize the restitution amount, and that's something I can only get from the state. And I know that Mr. Snell has made every effort to get that detail. Mr. Sanford was happy and ready to enter a plea today. If we could do that, we're just not there.
Yes, ma'am.
I do not want a full continuance. I think that Mr. Snell and I believe that if we could have a miscellaneous date in December, maybe a status date, it would certainly be our intention to resolve the case at that point.
Okay, and instead of setting it for that, and then if y'all don't have an agreement, clerk does all that work and everybody gears up, I'll just continue it until January 8th at 9 o'clock. But if you want to set a hearing before then, contact the clerk and just set it.
Will do. Thank you, Judge. And the last case I have is Michael Levins in 23 CF 1168. Mr. Levins is present and approaching.
Yes, ma'am.
And Judge, we've reached an agreement in his case, if I may approach.
Yes, sir. Yes, ma'am. Hello, Mr. Levins.
Good morning.
Thank you, ma'am.
In 23 CF 1168, Mr. Levins is withdrawing his previously entered not guilty plea and entering a no contest plea. Count 1 is the lesser included of carrying a concealed weapon. That's going to be under Florida Statute 790.01 subsection 1. It's a third-degree felony. He'll have 36 months of probation, $40 per month cost of supervision, $515 in court cost. He'll have to attend and show proof of a batterer's intervention program, consume no drugs or alcohol without a valid prescription, attend 2 AA meetings per week, and continue to access psychiatric care and take any and all prescribed medications. In addition, a letter of apology to Officer Richards. Count 2 is as charged. That would be 11 months and 29 days probation to run concurrent with Count 1. Count 3 is being dismissed, and then Count 4, he's pleading as charged, 11 months and 29 days probation, all of that to run concurrent with the 36 months probation. And then there is a note in the plea, any confiscated firearms may be returned to Wayne Vines. He is to be adjudicated, Judge.
Okay, thank you. Mr. Levins, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Levins, did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes.
Did she answer all of your questions?
Yes.
Are you satisfied with the representation?
Yes.
Did you sign the plea agreement?
Yes.
Mr. Levins, I do accept your plea. You're adjudicated guilty. In Count 1, it's to the lesser included offense. You're sentenced to 36 months probation. All of these sentences are to run concurrently, run at the same time. You need to pay the $40 per month cost of supervision, the court cost, attend and show proof of successfully completing the batterer's intervention program, consume no drugs or alcohol except with a valid prescription. You'll need to submit to random breath tests, random urinalysis. You need to attend 2 AA meetings per week. You need to continue to access psychiatric care and take all prescribed medications and do a letter of apology to the Officer Richards. Count 2 as charged. Thank you. Count 2 as charged, 11 months, 29 days probation. Again, that's concurrent. Count 3 is dismissed. Count 4 as charged, 11 months, 29 days probation. All of those concurrent. The subject firearms may be returned to Wayne Vines. Thank you, sir. Good luck to you.
Thank you.
Thank you, Judge. And that's all I have this morning.
Thanks, Ms. Maryville. Mr. Garrett,
Actually, Your Honor, if we could briefly pass my cases.
you just let me know when you're ready, okay?
Thank you, Your Honor.
Good. Okay. Ms. Jaquith?
Morning, Your Honor.
Morning, ma'am.
The first I have is Hannah Howell in 23 CF 1924. Okay, perfect.
Hello, Ms. Howell.
Your Honor, we are ready for trial in this case.
Okay. Is it going to go next week, the week after?
Your Honor, I'm still waiting back my FDLE from that. So,
Set it for Wednesday and try to schedule it on Wednesday. If we don't have it by Wednesday. Hold on, Your Honor, I'm sorry.
Sure.
okay.
Yes,
Can we
sir.
approach?
Yes, sir.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Day at 9 o'clock,
Yes, sir.
and then we'll figure out whether we're going to trial or not, okay? Thank you.
Thank you.
I just want to put on the record, Your Honor, the offer is to withhold a year probation, and that offer is going to be revoked after today, so it's not going to be available anymore.
Okay, Ms. Howell, do you understand that? My job isn't to talk you into anything, it's just to make sure that you understand as much as I do, and the state saying they offered you that. If you don't take it today, they're saying they're not going to offer it again.
Right.
I can't make them offer it. The separation of powers doesn't let me do that.
Right.
So I just want to make sure you understand that.
Judge, can we pass Ms. Howell for just a few minutes?
Sure.
I don't want to hold the court up.
Okay.
Just have a seat, and I'll talk to you in a second. Okay. Your Honor, the next I have is Mr. Neal, Douglas Neal. He's present and approaching. Mr. Neal, come on up. That case number is 23 CF 1832.
Hello, Mr. Neal.
And Your Honor, in Mr. Neal's case, we have reached an agreement with the state. Mr. Neal is going to be pleading no contest as charged. The agreement is that he'll be adjudicated guilty, which he has previously been. He will be sentenced to time served. He will need to pay $615 in court costs and $150 costs of defense. Count 2 is a misdemeanor, will be adjudication of guilt and time served as well. And Your Honor, I would just ask that the court give Mr. Neal a year to complete those payments before they're sent to a civil lien.
Okay, thank you.
May I approach?
Please, Mr. Neal, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. Mr. Neal, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Neal, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You'll need to pay the court costs, $150 public defender's fee. If you fail to pay those within 1 year from today, then they will go to a civil lien or judgment. Thank you, sir.
Thank you.
Just get fingerprinted and then you're free to go. Your Honor, the next I have is Ron Peterson. And Your Honor, if I could just pass Mr. Peterson for a few minutes. I know he doesn't drive and he comes from Walton County. So then I have Christopher Rogers, who is an inmate in 23 CF 2116.
Okay, it didn't show he's an inmate, but
So I
he is.
emailed, and the problem is he's not an inmate in this case. He's an inmate in a different case. I did email last week to let them know that he was, not only that he was an inmate not in this case, but in a different case, but that he was also listed in the jail's log as a ROGERS and not an RODGERS, which I think is causing the confusion. Regardless, Your Honor, this case was going to be continuance. It was left on for today because he wasn't here on last Monday, but last Monday he was also still incarcerated on that other case. I did speak with his mother, who indicated that she had intended to bond him out. However, she was waiting to get some more information, I guess, from DJJ, because Mr. Rogers is a juvenile, and she wasn't sure if she bonded him out, if he was going to get out or go back to DJJ. There was some confusion. So I would just move to continue this case. I do have good contact with his mother, so I have no concerns about him being in contact with me. I also believe, if I understand correctly from some of the state attorneys in Judge Ketchell's division, that this case is likely going to be transferred over there anyway, so there's nothing we can really honestly do with it at this point.
Okay. I don't know if it was Mr. Rogers' case, but there was one case that I received a proposed order to transfer divisions, but my case number was lower than Judge Ketchell's, and I put why, but and it may not have been this case. Also, when y'all do a motion to transfer, if you'll give me the case number of the other case, because then every time I have to look it up and see if their case number's lower than mine, and then I sign it, and if not, then, and maybe that'll also prompt y'all to look, but if you'll let me know in the motion, that would help.
And I will tell the court, for this particular defendant, there are multiple co-defendants in this case. There are co-defendants who have been transferred to this division to run with other co-defendants and now need to be transferred back. I mean, it's a mess because of the amount of co-defendants and the amount of co-defendants who already had cases and where those cases were. My understanding is that it was a lengthy conversation about where all of the cases were going to go because these cases are significant trafficking cases.
And so it may be
It
this
may
case.
have been this case.
It sure may have been. Just let me know. And maybe I missed that in the motion. If it said co-defendants versus a lower number, then I'll certainly sign that.
So I'm not really sure, I don't know if you guys have even done the motions yet for this one, but I just want to let the court know, when you see this name come across your desk, that there was
Co-defendants.
lots of co-defendants and lots of conversation about that. But at this point, I think we just need to continue it to January 8th so that the state can get everybody where they need them to be.
Okay, and Mr. Rogers knows that you're going to seek a continuance?
I told his mother that we would be continuing it. This is a trafficking case, Your Honor, and I've not received the discovery yet.
Okay, it's continued one cycle.
Your Honor, the next I have is Kendall Schumacher. And Your Honor, if I could pass Mr. Schumacher, he wasn't in the courtroom earlier.
Okay? Yes,
And finally, Tyler Smith. Mr. Smith is present. I'll pass you, just have a seat for a second. Mr. Smith, if you want to come up.
Hello, Mr. Smith.
And Your Honor, I just need to pause for one moment so I can grab the plea agreement for Mr. Smith from the state.
Okay.
Yes, please. You guys sent, but I just. Your Honor, Mr. Smith is present in 23 CF 1236. He is going to be entering a no contest plea as charged. The agreement with the state is that he be adjudicated guilty, placed on 3 years of probation. He will need to pay $40 per month cost of supervision, $515 in court costs, a $150 cost of defense, and forfeit the firearm in question. And Your Honor, Mr. Smith was a resident of Illinois at the time this happened and remains a resident of Illinois. We put him on for today so that he would have sufficient time to go to probation, do all the paperwork he needed to do, and then be able to get back on his way back home.
Okay.
So if I may approach, I just wanted to make sure that everyone was aware.
Thank you. Mr. Smith, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Smith, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did she answer all of your questions?
Yes, sir.
Are you satisfied with her representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Smith, I do accept your plea. You're adjudicated guilty. You're sentenced to 3 years probation. You need to pay the $40 per month cost of supervision, the court costs, the $150 public assistance fee. Subject firearm is forfeited. The court has no objection to you transferring your supervision to Illinois, but you got to get the approval from probation here before you leave. So talk to them before you leave the courtroom, okay? Thank you, sir.
Okay, so you gotta get fingerprinted, then talk to her right there. Okay, and then she'll give you the directions on where you need to go. And Your Honor, I will step back and speak with Ms. Howell and Mr. Schumacher and get in touch with Mr. Peterson and get back.
If you'll let me know when you're ready.
Yes, sir.
Before I do you, Mr. Garrett, I think Teresa's back in. Teresa, are you ready with Mr. Powell?
I'm ready.
Okay, Mr. Powell? There he is. Oh, okay.
Good morning, Judge.
Good morning, Mr. Powell.
Bueno, pasa. Va a pasar por aquí, por favor. Mirando al juez. ¿Pasa por aquí? Va a firmar
Good morning,
ahí,
sir.
señor. Va a firmar ahí.
Good morning, Judge.
Good morning, sir.
Bo Powell for Luis Moroyoki, 23 CF 1701. We have a negotiated plea agreement. If I could approach.
Yes, sir. Thank you, sir. Thank you. Good morning. Mr. Moroyoki, if you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sí, señor.
Yes, sir.
Was the plea agreement that you signed, was it read to you in Spanish?
Sí, señor.
Yes, sir.
Do you understand it?
Sí, señor.
Yes, sir.
If I accept your plea, what are you going to be sentenced to today?
Un año probatorio.
1 year of probation.
Do you have any questions for the court or your attorney or the state?
No, señor.
No, sir.
I do accept your plea. Adjudication is withheld. You're sentenced to 12 months probation. You'll need to submit to a substance abuse evaluation within 30 days from today. Let me make that 45 days from today since there's Thanksgiving. If any treatment is recommended, then you'll need to begin that treatment within 75 days of today. You'll need to perform 24 hours of community service work and pay the $615 in court costs. You'll also need to pay $40 per month cost of supervision. I don't see where the cost of supervision was on your written plea agreement. Did you understand you were going to have to pay that? Was that explained to you before today?
It's $50 a month.
Yes, sir.
Okay. Thank you, sir. Good luck to you.
Judge, would the court allow a buyout of the community service work?
Yes, sir.
Sí, señor. ¿Ok? Es todo y se puede retirar. That is all I have, Your Honor.
Thank you so much.
Thank you.
Happy Thanksgiving.
Same.
Thanks, Teresa.
Thank you, Judge.
Thank you.
Have one other matter on the docket. It's Mahaley Rozier,
Ms. Rozier?
and she's present. It's 23 CF 1591.
Yes, sir.
And the state and I are getting pretty close to a resolution, asking for a continuance to, I think we'll get it worked out next cycle, though.
Okay. Ms. Rozier, I'll see you back here no later than January 8th at 9 o'clock.
Okay.
If the state offers you something you want to accept, I'd encourage you to set that before that date, because that date the courtroom will be overflowing with people.
Yes, sir.
Okay? Thank you, ma'am.
Yeah, no problem. Thank you.
Thank you, Judge. That concludes my business this morning.
Thanks, Mr. Powell.
Have a good Thanksgiving.
You too. Thank you. Mr. Garrett?
Good morning, Your Honor.
Good morning, sir.
Your Honor, if I can call my first client out of order, Mr. Eduardo Rosales Zelaya, case number is 22 CF 2490. He is present and approaching. Thank you. Your Honor, we're going to change a plea here, a plea of no contest to the lesser included offense of misdemeanor battery. If I may approach with the plea and sentencing agreement?
Yes, sir. Thank you, sir.
Morning, Judge.
Good morning, sir. And I'm sorry, Teresa, were you previously sworn in some other court?
No, Your Honor, I
Okay.
was not.
Madam Clerk?
Do you swear or affirm that you will give an accurate, complete, and impartial interpretation from
the Spanish language into the English language and vice versa relative to the cause and other considerations for the court.
I do. Thank you, ma'am. Did you read I'm sorry, was the plea agreement read to you in Spanish?
Sí.
Yes, sir.
Do you understand it?
Sí.
Yes, sir.
Did you sign it?
Sí.
Yes.
Just basically, what will you be sentenced to if I accept your plea today?
11 meses de probación.
11 months of probation.
Okay. It's actually what it says is 11 months, 29 days, so it's almost 1 year. Do you understand that?
Sí.
Yes.
Do you still wish to enter the plea?
Sí.
Yes.
And then it has that you'll need to take an anger management class, perform 50 hours of community service work. The court would award restitution, but reserves jurisdiction to determine the amount of that restitution, meaning what may be owed to an alleged victim. You'd have to pay court costs. Do you understand that?
Sí.
Yes.
Do you still wish to enter the plea?
Sí, señor.
Yes, sir.
I do accept your plea. Have you ever been adjudicated guilty of a felony before? Is this a felony? It's a lesser included.
Lesser included misdemeanor, Your Honor.
Okay. So you're adjudicated guilty of a misdemeanor, not a felony. It's misdemeanor battery, as Mr. Garrett stated. 784.03 B. You're sentenced to 11 months, 29 days probation. You'll need to enter and successfully complete the anger management class, perform 50 hours of community service work. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution. You'll need to pay the court costs. You will be supervised by JCS. Probation shall convert to administrative probation, non-reporting supervision after 6 months. If you have successfully completed all the terms of your supervision at that time and haven't committed any new law violations. You may pay off the community service work at the statutory amount. Did I miss anything for this sentence?
I don't believe so, Your Honor.
Thank you, sir. Good luck to you.
Gracias a usted.
Thank you.
Thank you, Your Honor.
Es todo. Esto se queda aquí.
This is for you.
Yeah, and go talk to probation.
It's GCS though.
Yeah, what do you-
She has a call.
Oh, go put it over there. Sorry.
I'll get it.
Okay, thank you so much. Your Honor, returning to alphabetical order, Chris Garrett on behalf of Toy LaRocca. She has 3 cases on the docket, 21 CF 1251, 23 CF 1942, and 23 CF 573. We have received the confirmed offer for the felony violation of probation. It should be 21 CF 1251. If we could set that case for a miscellaneous date in December, we could potentially get it resolved, or if Your Honor thinks it'd be more efficient to just continue all of our cases to January and resolve the felony VOP at that point.
It's up to you. You've got to tell me whether you think you're wasting your time to come for that, or
Yeah, I'll leave that up to you. Full continuance is fine.
We just do a full continuance, Your Honor. That would be my only straight case on the docket.
and then, Mr. Garrett, if you want to set a hearing before that date to enter a plea, then please do.
Thank you, Your
So
Honor.
it's continued,
And that was to January 8th?
correct.
Thank you. Then Chris Garrett on behalf of Brandon Mallon, 23 CF 421. Your Honor, this is going to be a PTI without a plea. We don't quite have the document yet. I know the state is working on that. If we could set him for January 8th, I'd anticipate that we'd get the PTI filed before then.
Yes, sir.
And then finally, Chris Garrett on behalf of Felicita Mickelson, 23 CF 1377. Your Honor, the state would ask for just a little bit more time to speak with the alleged victim in this case. There are some health issues going on. No objection from the defense. If we could just leave it set for January 8th.
That's correct, Your Honor, and if we can come to a resolution after I speak with the victim, then we'll set it for a date in December to get
So
that
the
resolved.
state's motion for continuance is granted.
And I believe that's all I have, Your Honor.
Thanks, Mr. Garrett.
Thank you, Your Honor. Have a good day.
Happy Thanksgiving.
You too.
Thank you. Okay, I don't see any other private counsel. No private counsel on Zoom that I'm aware of. The unrepresented defendants, I was going to take LaRocca last, because I think that'll take longer. Rosella Payton. Okay, yes, ma'am. Okay. Samuel Reeves, 23 CF 234. Does the state have an offer for Mr. Reeves? R-E-E-V-E-S, pro se, 45 on my list.
Right. Turn to the page.
I had record where I completed everything that it was saying I hadn't completed.
Okay.
And,
Okay, hold on one second. I just don't want you to say something that'll hurt your case, okay? Let's see what the offer is from the state, if it's something you want to take, and waive your right to a trial by jury and an attorney. You can do that. If they're offering prison or something, then we'll talk about appointing a public defender. Okay.
So, from what I can tell, this is a pretrial intervention recall.
Okay.
And I'm not sure why.
So do you have an offer?
Are you think you've completed everything?
Yes,
on
I
the
did. I
pretrial
completed it.
intervention?
Yeah, I've done my community service. I went to Dr. Kinsey. I've done all the things that I was supposed to. And then I just got a thing in the mail saying that it had a revoke on it for something, a technical something. But I've corresponded back and forth with the PO, and he's never messaged me back. So I started actually messaging Ms. Brooks, and she let me know today was the date for court. And
Do you want to continue it until December 18th? And if the state can figure out that he's fulfilled everything on PTI, then you cancel the hearing and let Mr. Reeves know he didn't have to be here?
That would be ideal.
Okay.
Yes, sir.
Mr. Reeves, so I'll see you back here December 18th at 9 o'clock, unless you hear from the state that says you don't have to be here because they're dropping your case.
Okay, thank you.
Thank you, sir. Okay. Hello, Mr. Payton.
How you doing?
Good, how are you?
Good.
So, Mr. Payton, it shows that you don't have an attorney. Have you filled out a financial affidavit for an attorney to represent you?
No, I didn't get the form.
Okay. How much money do you make per month?
Nothing.
How long have you been unemployed?
For over a year now.
Okay. I do appoint the public defender to represent you. Mr. Koch is approaching on your right.
Good morning, Judge.
Good morning, sir.
Were we here on...
This is Mr. Roselle Payton.
Yes, Judge.
And it was on for docket day. It's interesting that he got this far without an attorney, so.
Well, Your Honor, just for your knowledge, we set it on this date today because he was looking at private counsel, and you wanted to make sure that he came in and had counsel when we left court
good.
today.
Thank you. Okay. Yes, sir.
Your Honor, for just being appointed, I'd request that we set this for the January 8th pretrial conference.
Mr. Payton, I'll see you back here no later than January 8th.
Okay, sir. I had put in for a motion for speedy trial like a week ago.
Okay.
I didn't know that the state or anybody get my letters yet, but I had wrote and filled out the motion already.
Now that you're represented by counsel, he will need to either adopt that motion and let everybody know so we know that it's running, or not. So, Mr. Koch, make sure that if you adopt that motion, that you let me know and we make sure that we get all the time periods fulfilled.
Yes,
Okay?
Judge.
Good.
Okay, sir. So even though I put this motion in, I have to talk to him now about it since I put it in like a week ago.
Correct.
All right.
Right. So I'll see you no later than January 9th, January 8th.
Where you going?
I'll see you. Yes, sir, Mr. Garrett. You're back.
I was asked to cover for Robert Dees.
Okay.
I believe his
Suarez.
client is present.
Last name is Suarez, Your Honor.
Robert Suarez?
And
Hello,
Suarez.
Mr. Suarez. 23 CF 1396.
Your Honor, I believe Mr. Dees was going to request a continuance to the pretrial. I think there's a PTI paperwork that the state probably
We're
knows
going to
about.
get him a PTI contract, Your Honor.
Good, excellent. Mr. Suarez, I hope that everything goes through on pretrial intervention. It's a diversion program. It goes around the court. If you do everything that's required to that, then your case is dismissed. Unless that paperwork's all finished and Mr. D says you don't have to be here on January 8th, I'll see you on January 8th at 9 o'clock.
Yes, sir.
Thank you, sir.
Thank you.
Thank you, Your Honor.
Thanks, Mr. Garrett. Don't see- Ms. Jakewood, do you have something else?
Your Honor, I'll recall Hannah Howell. Ms. Howell's present and approaching.
Hello again, Ms. Howell.
That case number again, Your Honor, 23 CF 1924. And we are prepared to go forward to trial.
Okay,
So we'll be back on the 22nd, or on Wednesday at 9.
okay. I'll see you Wednesday at 9 o'clock, okay?
Yes, sir.
Thank you, ma'am.
And Your Honor, Mr. Peterson did contact my office, and I apologize, I hadn't checked my phone, but he did contact my office, his ride didn't show up, so he had to make other arrangements, and he was on his way. So I expect him any moment, and it'll be a plea, so.
Sounds good.
And Your Honor, finally, I have Kendall Schumacher, who's present and approaching. Mr. Schumacher's case number is 23 CF 1338. It was set for plea or trial today,
Yes, ma'am.
and I'm prepared to go forward to trial.
Okay.
I believe Mr. Schumacher may want to address Your Honor.
Okay.
Judge, can I request to approach?
No, sir. You're represented by counsel. She's your mouthpiece to the court, so there's only a couple things that the court really recognizes from a pro se defendant. So I need to know what
I understand.
you're seeking.
I have a couple concerns. Mainly Marcy's Law. Under the Amendment 6, I've requested counsel to invoke Marcy's Law because of...
What does Marcy's Law mean to you?
Me, it's protection of my privacy and the protection of my spouse.
Because you're a victim?
Not just in, yes, in multiple cases that these courts have heard, and I've already have.
How is that going to affect you going to trial?
It's the protection of privacy will, under Amendment 6, because of...
At this point, I'm not recognizing your standing to do that because you're represented by counsel.
Cool.
So is the state ready to go to trial on Mr. Schumacher's case?
I have the subs out, yes, sir.
Okay. Are we going to go next week or the week after?
Your Honor, this is a simple possession case where Mr. Schumacher was the sole occupant and admitted to knowledge, so I can be prepared whenever the court, if the court wants to go Monday, that's fine.
Okay. What day next week do you want to do it?
And Your Honor, I do have a motion hearing that I believe will cancel, but I don't want to tell the court that and then have it not cancel. That's scheduled for the 27th at 10 a.m. So I could either pick that afternoon and go another day, or I could do a pick and go. I don't anticipate this case will take long.
Let's see if I can find a calendar on this computer.
Is it possible if we can set the date Wednesday on the 22nd?
And I'm fine with that, Your Honor.
Okay, does Mr. Schumacher, well, we want him here if we're going to schedule the trial. Okay, so Mr. Schumacher, I'll see you Wednesday at 9 o'clock, and that's when we'll tell you when you're going to trial, either next week or the week after that. So I'll see you then.
Yeah, is there any way to push that out a couple days?
No, because that would be the Friday after Thanksgiving and we're closed. Why don't we you don't want to give just Mr. Schumacher a trial date and time now? Because you're scared about what's coming up? I mean, we've got a lot of other dockets, and so you want to coordinate it better? I mean, is that what your overall feel is? It looks like it. Mr. Schumacher, I'll see you back here Wednesday at 9. Okay, thank you.
Did you file a motion for
Violation of the Sixth Amendment?
Yes, sir, Mr. Nopes?
Sir.
Good morning, Your Honor.
Morning, sir.
I've got, if I could, I've got a case for James Owens that he asked me to cover.
Okay.
It's Seth Laviolette, Laviоll.
Thank you. Yes, sir.
He says that they were waiting on body cam footage to decide how best to proceed. He asked me to continue it because he believes that the videos, based on what his client said, is he believes the video is going to be exculpatory, but I don't know what the state has to say.
Mr. Seth Laviolette, I assume he filed a waiver. I don't see Mr. Laviolette. The continuance is granted.
Okay. Is that January 8th?
Yes, sir.
Okay. Judge, I then have Michael Ladson. Sure, we'll do that first.
Hello, Ms. Shelby. Good, how are you?
Judge, I filed a motion to have a mental health expert appointed yesterday and sent through a proposed order, so I just asked for January 8th.
Yes, sir. So, Ms. Shelby, hopefully between now and January 8th, you'll see a doctor, and then I'll see you on January 8th, okay? Thank you, ma'am.
See you later.
Thank you. Thank you, ma'am. You too.
Any updated offers on McNamara? No.
Oh, Mr. Ladson.
Good afternoon. Good morning.
Yes, sir. Good morning.
So, Judge, on Mr. Ladson's case, I filed a motion to withdraw yesterday evening. Me and Mr. Ladson are basically fundamentally in disagreement as to the steps that need to be taken in the case. And according to Florida Bar Rule 4-1.16, subparagraph B2, I don't believe that I can continue to represent him.
Okay. Let's see if I can find that rule. That's an administrative rule? Rules regulating the Florida Bar professional conduct?
see.
Got it. Okay. I think I've got it, Mr. Rhodes. Okay. Your motion to withdraw is granted.
Judge, I'll send the proposed order later today.
Okay, and if you'll contact, I don't know who's next on the list. Madam Clerk, do you have that? Okay. If you want to just ask the clerk, or you can just put a blank line in there and we'll fill it in.
That's what I've got prepared.
Okay, good.
And we're willing, is the system allowing us to send orders now, proposed orders again?
I would send it via email just to be sure. Send it to Donna via email.
All right.
Okay. Mr. Ladson, then I will see you back here. Let's set it for a status conference and make sure that you get with your new attorney. I'll set it for December 12th at 9 o'clock, okay? So the underlying case is continued until January 8th, but I'm going to set it for a status on December 12th just to make sure that we can get you together with your attorney. Okay?
Yes, sir.
Thank you. Please. Good. Thank you, Mr. Nopes. Very nice. Good.
Judge, I just wanted to point out, I don't think we have a court date on December 12th. It's December the 11th or the 14th.
Because I'm looking at next year again. Okay? So let's do December 14th. Yes, ma'am. Thank you. I keep flipping the page, and I shouldn't do that. Thank you, Rachel.
Judge, if I could back up to, I'll just email you the order because I had written on these as I think I've already sent you proposed orders to the portal on Misty Shelby.
Okay.
But if you want me to, I'll forward the
You
order to.
Send it directly to me.
I will, Judge.
Okay.
Brandon Lee, Judge, he texted me a little bit ago and said that he was having to walk, and so I told him to come on. I expect a plea here in a little bit.
Good.
Julian LaBello, but he's present.
Your Honor, if Mr. Nopes and I can approach.
Yes, sir.
Is that bad?
Background Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Core Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
So, Mr. LaBello, the state's asked for a motion for continuance. I'm going to grant that, so I'll see you back here on January 8th at 9 o'clock, okay?
Wait on me outside. I'm not used to writing 24 yet.
Yes, sir.
Then I've got Kevin McNamara.
This is who I was asking. You got any update on that? I don't. I've been trying to work through these trial cases. I'm sorry.
Judge,
set it for Wednesday, and let's set it for Wednesday, and I'll
okay.
work through it, yeah.
Judge, the state and I have been trying to come up with a resolution that everybody can live with. So if we could set it for Wednesday, that gives him a couple extra days to look at his file again and try to get an offer that we can live with.
Good. Mr. McNamara, I'll see you in 2 days.
Thank you, Mr.
Thank
Brown.
you, sir.
Thank you.
You bet. So that's 11/22, right?
Yes, sir.
Judge, I then have Joe Petit. Judge, he's here.
Your Honor, I wanted just to speak candidly. This is a case, we had received FDLE on the main trafficking charge. That actually came back because there was no controlled substances found. So we're just in the process of trying to get a deal put together with the remaining charges. I would just ask if we can set it for 1/8. There's a very, very high chance that we get this in December 14th or a December 11th date to plea in. I just need some time to look at the remaining charges, and to be quite honest, I've been really focused on the trial cases, so if we can, but just know that the main charge, the trafficking and fentanyl, that's going to be null pros because the FDLE report came back no controlled substances found.
Mr. Petit, with that knowledge from the state, I'm glad that you're not incarcerated. We'd be having a longer discussion. I'll see you back here no later than January 8th at 9 o'clock. If Mr. Nobes wants to set a hearing before that date, then I'll see you then.
Okay.
Thank you, sir.
Thank you. Happy Thanksgiving.
Judge, I then have Lucas Simplicino, and I just need...
Luciano?
Yeah, that's it. That's it.
We'll approach on that.
Yeah.
There he is, behind you to the right. Okay, so you're asking to approach, I take it?
Yes, sir.
Okay, yes, sir.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Really wants some additional time. Mr. Nopes will tell you that it sounds very favorable. And so I'm going to continue it until January 8th at 9 o'clock. The state may have something that they want to offer you that you may want to accept before that date. If so, Mr. Nopes will set you for a hearing. And I have to just smile. The state remembers you from Veterans Court in a very positive light. Okay? So January 8th at 9 o'clock.
Thank you.
Thank you.
On the outside. Okay, I'll tell you what's going on. Judge, then I've got the last case is Peter Tran.
Mr. Tran. Good morning, sir.
Judge, it was my understanding that the alleged victim in this case wants the case dismissed, and I just asked the state if they had gotten anything. And I understand he's trying to get accommodated with the cases now that they're, and this case is not very old. I believe it might be best just to put it on January 8th and give us a chance to knock the idea around that she may want the case dismissed.
Good. Mr. Tran, I'll see you on January 8th at 9 o'clock. If the state talks to the victim and decides to dismiss your case, Mr. Nopes will let you know. Okay? January 8th, 9 o'clock.
Yes.
Thank you, sir.
We're on the outside. And Judge, as soon as Mr. Lee gets here, I'll come back in, maybe we can wrap him up.
Okay, good. Thank you. Mr. Cobb?
First I have is Joan Rudd.
Yes, ma'am. Whoever you've got, Rachel.
Sorry.
Ma'am. Okay. You want to, if you want to just write his name there, email him there. Good.
Okay. Judge, I just need to get her to sign the plea.
Okay. Hello, Ms. Rudd. Good morning.
Hello, good morning.
Okay. And terminate after paying the restitution.
Ms. Rudd, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down.
It's going to be a change of plea, of course. I'm doing the plea form. I can go ahead and announce the terms. It's Ms. Rudd in her case. I think it's 1987 is her case
Yes,
number?
sir. Correct.
Okay, 2020, 1987. She's going to withdraw her plea of not guilty and her plea of no contest to the charges with the understanding that the terms and conditions of the plea will be sentenced to time served in the Okaloosa County Jail. And she's going to be placed on 12 months of probation, but the purpose of the probation is solely so she can pay back restitution in the amount of
$135.49
$135.49
to Walmart.
to Walmart. And it's going to be, once the restitution is paid, the state has no problem with probation being terminated.
Okay, it's adjudication of guilt or withhold?
It's adjudication of guilt.
And that's on each count to run concurrently?
Yes, sir.
Well, okay. Ms. Rudd, have you been adjudicated guilty of a felony before?
Yes, sir.
Okay, please.
That's why I said adjudication of guilt.
Okay. Ms. Rudd, did you read the plea agreement?
Yes.
Do you understand it?
Yes.
Did you sign it?
Yes.
Ms. Rudd, I do accept your plea. You're adjudicated guilty. You're sentenced to 12 months probation on each case, each count to run concurrently, run at the same time. However, if you pay the $135.49 in restitution prior to the expiration of 12 months, then your supervision will automatically terminate with a caveat. Let me find out. Does Ms. Rudd also need to pay the court costs within that time period?
Yes, sir.
Okay, so you need to pay the court costs and the $40 per month cost of supervision. So if you pay those, then your supervision will automatically terminate. Otherwise, you have 12 months, okay? Thank you, ma'am.
Thank you.
Okay. Hey, see you later.
Okay, thank you. I appreciate it.
Okay. Victor Robinson. Judge, despite my best efforts with Mr. Snell, I couldn't bring this one in for a landing for the holidays. So I spoke with Mr. Robinson.
Okay.
This is Victor Robinson present before the court in 2023 CF 361, 702, and 888.
Yes, sir.
We're going to leave him on the docket for January 8th, and I've sent over emails about the depositions to schedule.
Good.
So that we can proceed that way. They would have been scheduled, but then Ms. Davis transferred her cases to Mr. Snell, so there's been a little bit of lag, not much. But January 8th, if we can leave it there, that'd be great.
Mr. Robinson, I'll see you no later than January 8th.
Yes,
Okay.
sir.
Thank you, sir.
Okay, I'll see you, buddy.
All right.
Thank you, Mr. Cobb.
You don't mind, you come see me?
Yes, I will. Okay. Those are my cases, Judge.
Yes, sir, thank you. Ms. Jacob?
Excuse me, Mr. Ron Peterson on the docket. Mr. Peterson's present and approaching from the back. Your Honor, we've reached an agreement with the state. Those case numbers are 21 CF 1964 and 21 CF 1965. Mr. Peterson's going to be pleading no contest as charged. On all counts in both cases, he'll be sentenced to an adjudication of guilt and time served. He has been previously adjudicated. There will be $515 in court costs in the 1964 case and $150 costs of defense. In the 1965 case, there are $615 in court costs. That includes the extra $100 for the FDLE fee and a $100 cost of defense. The state will take no action on any failures to appear in either case. In exchange for this plea, And we would ask that the court provide Mr. Peterson 12 months to complete the payments. The score sheet does reflect a state prison sentence, so this is a legitimate uncoerced plea bargain, and that is marked on the score sheet by stipulation. May I approach?
Yes, ma'am. Thank you, ma'am. Mr. Peterson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Peterson, did you read the plea agreement?
I did, Your Honor.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Peterson, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You'll need to pay the court cost, $250 public assistance fee. If you fail to pay those within 1 year, then they'll go to a civil lien or judgment, and this is a negotiated plea, so that's why it's a downward departure.
Yes, sir.
Thank you, sir.
Thank you.
Okay, just get fingerprinted and then you can go.
And you didn't mark downward departure.
Oh, I may not have, Your Honor. I didn't mark the downward departure box, but I marked the reason for the downward departure, so I apologize.
Good. No, ma'am, not a bit. Thank you so much.
Thank you. Those are my cases. May I be excused?
Yes, ma'am. Thank you. Since we've been working over an hour and a half, we're going to take a 10-minute recess, and then we'll finish the morning. Thank you.
All rise. Court is now in recess.
Out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with? I think I was bit by a vampire. This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalwear, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalwear. We're located at 648 North Wilson Street. Call 850-682-2446. C&C Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law. for your recent jury verdict of $11.5 million for your client from a death and injury against an
Okay. Mr. Stevens, if you want to have a seat, we'll call you when we find Mr. Koch. Mr. McKinney, you want to start with your, I was thinking with Mr. Klein's not here taking his cases last.
I think I've been running in circles, Judge. I believe we're ready to go ahead and handle his cases if we wanted to do that.
Is that what you want to do first?
I have a few of mine that we could handle out of the gallery.
Yes, sir, please.
That would be Mr. Christian Viljoen. Oh, he was just in the courtroom. Not
Okay.
cool.
Who else is in the gallery?
Nikki Smith is present in the courtroom.
Nikki Smith?
She's here in 21 CF 2090 and 21 CF 3255. Judge, we'd set this over primarily as a status plea or continue today. And to be frank with the court, I haven't had the opportunity to go through this in full with Mr. Gomez to come to a restitution amount. We're discussing a pay and dismiss in one of these cases, which would resolve the one of the cases, the 2090. And we have to get some firm numbers on the 3255 before we can move forward. I'm going to request a continuance today, but I wanted to give the court a snapshot of where we're at with it.
Thank you. So, Ms. Smith, I'll see you back here on January 8th at 9 o'clock.
Okay, thank you.
Thank you, ma'am.
And I have
Don't forget the folks also on Zoom.
I have Mr. Steven Zamora on Zoom.
Mr. Zamora.
How's it going, Judge?
Good, how are you?
Pretty good, pretty good.
Good.
Judge, for Mr. Zamora in 23 CF 1203, we have a plea offer from the state that I've discussed with Mr. Zamora. It's for a misdemeanor. He wishes to accept it if the court would do so orally.
Yes, sir.
Currently as charged, this is a third-degree felony. This would be reduced down to a misdemeanor, leaving scene of an accident without injuries. That would place Mr. Zamora with an adjudication to a misdemeanor on 6 months of JCS probation. We would reserve over the issue of restitution. He would have to complete a basic driver improvement course. There would be standard costs.
Okay.
There's a restitution amount in the amount of $2,425 payable to the initials JAM, or I'll defer to the state if you would like to go that somewhere else.
Judge, that would be, I guess, to the parents of JAM. So we're not going to reserve over restitution. We have made a restitution determination.
Okay, good.
Mr. Zamora will accept that. Instead of the reservation over the restitution, we will accept the $2,425 amount. Mr. Zamora, did you hear everything that we just talked about in the courtroom?
The last
last part, I couldn't hear that well.
That was pertaining to the restitution. We discussed a $2,425 amount. We're just making sure that it went to the right place.
Yes,
Okay.
that's correct.
And the amount for JCS, is that who it is?
JCS would be $50 a month cost of
Per month.
supervision.
Right, okay. Mr. Zamora, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. So, Mr. Zamora, here's what I've heard, is that if you wish to accept the plea, you'd be waiving your right to a trial by jury, you'd be adjudicated guilty of the misdemeanor, you'd be on probation for 6 months, you'd have to take and complete a driver's improvement course, pay the court costs, $150 public defender's fee, $50 per month cost of supervision, and pay $2,425 in restitution to the parents of JAM. Is that what you wish to do?
Just one quick question. How long do I have to pay the restitution?
6 months.
All right, yes, I accept.
Okay? Mr. Zamora, that's your sentence. Thank you, sir.
Mr. Zamora, please contact my office because you will need to contact JCS, Judicial Corrections Services. Do you have a pen to write down a phone number? If you don't,
For your office?
for the probation office. If you don't have one, then call my office and they can give you that phone number.
You need to get a number
Okay,
for
I'll call
him.
your office right now.
Get his phone number to provide to Tina as well.
I've got his phone number.
Madam Clerk, the statute number is 316.061. Judge, I have had the opportunity to meet with the victim's family regarding this case and discuss the evidence that we found in depositions regarding the extent of injuries. That's the justification for the misdemeanor on trial.
Thank you. Okay. Mr. McKinney, who's
We
next?
can move into Mr. Klein's cases. Yep,
yes.
Mr. Koch is present for that.
Mr. Stevens? Mr. Stevens, first, I received a motion, and are you seeking for me to determine if Mr. Koch is rendering ineffective assistance of counsel for you?
Excuse me?
Are you seeking to get rid of Mr. Koch as your attorney?
Correct. If there's a, I'm sorry, I lost my voice this morning.
Okay, if you'll pull that mic closer to you, or you can stand there. Yes, sir. Okay, so if you are, I'll swear you in, okay?
Yeah, well, I wanted to make sure before I did that, I would have representation. I don't want to represent myself.
If I determine that he's rendering ineffective assistance of counsel,
Then I will still-
then I would appoint the regional conflict counsel.
Okay, yes, please.
If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. Okay, so tell me, what I have to find is exactly what I said. I have to find that he's rendering ineffective assistance of counsel. So tell me what facts you believe fulfill that.
Man. Basically, they just seem too busy. Or I don't know if it's because what the charges are that I'm getting less, what am I looking for? Like I said, he just seems overworked, basically, and I haven't been able to have any prep time at all. I was not asked for a list of witnesses until a year later. I didn't know that that's something that was needed, you know. No depositions have been done. Nobody's even been contacted, I'm pretty sure.
I'm sorry, the end of that was what?
Nobody has been contacted on the witness list. I'm sorry, I had a list prepared, I forgot it.
Do you have that with you?
Excuse
You have
me?
your list with you?
No,
Okay.
it's part of it's right there on the, what I sent you.
Okay, so here's what you've said. Going to trial completely unprepared, Public Defender's Office has had very poor communications. I have not received any returned calls.
Yes,
You want to tell me
I've
about
left
that?
several voicemails to get calls back, and I have not gotten any calls back.
Okay,
As far as where I'm at right now, I feel like we're still in step one, and this is 2 years later, you know?
okay. And I'm talking about going to trial,
Correct.
right?
Right.
Okay. No depositions have been taken, you stated that. Motion for change of venue was never filed.
Right, I forgot. Yes, I mentioned I live in Escambia County as well, and I've mentioned that to, I believe it was when Mr. McKinney represented me, and nothing ever was spoken of that either.
Okay.
I don't know if I've gotten a full discovery file either. Looking at it, it seems very empty.
Then you say witness list was sent to council, but no witnesses' statements on record.
Right.
I wasn't even asked for a list of witnesses until a year after my arrest.
Right, right.
I was told a specialist or expert was to testify.
Yes, when this all started, Mr. Silicki, I think, was the expert's name, or it was somebody that Mr. McKinney said he was speaking to about my case.
Okay. And so it was, okay,
And nothing came of it, you know, that was all I heard.
multiple attempts to get updated on progress in any of these areas, but haven't heard anything except how busy council is.
Yes.
Okay. None of the documents for my defense have been submitted or even requested.
Basically, the change of change of venue or the list of witnesses or anything.
Okay. My trial begins soon, and I still don't have information, depositions, character witnesses, or a full discovery.
I don't believe so.
Anything else you want to tell me about that?
I don't believe so.
Okay. Mr. Koch, you'll raise your right hand.
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Do you want to testify from there or on the lectern? Okay. Okay.
Your Honor, the pretrial we had in September, the 9/11 pretrial, my client did show up in person, and he told me about witnesses he'd like to call. So I said, well, I need full names, addresses, phone number, as complete as possible. So he did work getting names, numbers. We had some phone conversations. Start off with partial names, but he did due diligence and get most names. I did file the witness list, Judge, on 11/9 before our last pretrial. And 1, 2, 3, 4, 5, 6, 7, 8. I have 9 names listed. Some partial names. I put everything I had for my client. As you see, it says Nick F. period. I want to make sure every person possible is on there. But there are full names and addresses on 1, 2, 3, 4, 5, 6. At our last pretrial, if you recall, I did say I was not ready for trial. I do have most names now, and I was seeking to do depositions on these witnesses. And this case does have some age, so that's where we are today on docket day. And to address the communication, of course, with our office, it's best to call ahead. You can schedule a telephone conference or an in-person conference. My client did schedule a telephone conference on October 10th, and he secured that about a couple weeks out, and of course, that conference was held by the telephone. I do see notes in my file leading up to pretrial, our recent pretrial, a couple days before. Of course, as you can imagine, I get calls from everybody right before pretrial, a couple days out, and just can't respond that quickly. That's why we always say the best bet is to schedule that appointment beforehand, a month out. And, Your Honor, that's all I have in this case.
How far before the last pretrial did the defendant try to communicate with you?
If I could have a moment, Judge.
Sure.
Judge, I have the November 8th voicemail with my secretary.
Okay, and the pretrial was when?
Yeah, November 13th, I just want to double check that, the November 13th, Judge.
Okay, thank you. Okay, what about, I think I know the answer, but the transfer of venue because he lives in Escambia County?
That was before Mr. Koch, I believe.
I did hear that, Your Honor, that wasn't a proper motion to file.
That was
I don't know if I even spoke to you about that or if it was Mr. McKinney.
Okay, the defendant, I think, wants you to file a motion to change venue where he lives,
Okay.
is what I gather, correct?
Right.
Okay. And why are you not pursuing that?
I believe it's improper to move this to...
Improper.
Yeah, to move
Okay.
to Escambia.
I missed the M part
Yes,
of that.
Judge.
Okay. And I agree. I'd never heard of a motion doing that before. Has Mr. Stevens been provided with full discovery that you have?
Judge, he has, and just to be clear, I did take over this case in July. I know this is a 2022 case. I only had a telephone conference.
You did send me that
On
email.
October 10th.
And that's all I've seen.
Okay.
Of discovery is that, like, what you sent me is what's lined up with what I've been able to receive.
Okay. So I did send that packet
Yeah.
early
Yeah.
during that telephone conference?
I think right after.
Okay.
Right.
I sent what I had, Judge, everything in the
Okay.
discovery.
And that could be a wrong opinion of mine to think that it looks empty. You know what I mean?
Understand.
Like, I don't.
Yes, sir. Thank you. Expert witness status, what's going on with that?
Since I've taken over the case, Judge, I haven't pursued that avenue.
Trial strategy, you don't think you need to
From
pursue that?
from what I have right now, Judge, but of course, I did get this new witness list, so that could change.
And speaking of the new witness list, you have enough information where right now you can subpoena additional witnesses for depositions?
Absolutely, Judge.
Okay. Mr. Stevens, anything else you want me to know?
Not that I can think of.
Okay. Mr. Stevens, at this point, I understand your concerns. I certainly have concerns with the last meeting, telephone conference being October 10th, that you contacting the PD on the 8th, the pretrial conference coming up maybe 5 days after that. It's a close call for the court, but at this point, I do not find that the public defender is rendering ineffective assistance. So respectfully, your motion is denied.
Okay.
Now, Mr. Koch, with that being said, are you seeking a continuance on your case?
I am, Judge.
To the state, any objection?
No, Your Honor.
Okay.
But we would like to address the court briefly on another matter regarding the witness list.
Okay. So, and Mr. Stevens, do you object to continuance of your case?
No.
It's continued one cycle and trial next time. Okay? Yes, ma'am.
Thank you.
To the state?
Judge, there have been numerous deadlines as far as providing reciprocal witnesses. And at this point, all we're asking is that today be the last day that they can submit any particular additional witnesses, that we get those people deposed. However, we would note that 3 of the 9 people on that list, under the rules of discovery, they have to provide a full name and address, and that has not been done.
I don't have an address for two, and I don't even have a last name for one. So obviously, we're not going to be able to subpoena or depose those people before next month or ever.
Okay. Mr. Koch?
Yes, Your Honor. And I agree with the state.
He actually is in jail right now, I believe. I just see him.
9, it does have 6 full names and addresses. The 3 remaining, I agree with the state. That's all I had. Could I get a deadline by 4 o'clock today, just to shore up the rest of that list?
Any objection?
No.
Okay, so 4 o'clock today, deadline for the defense providing the state with an accurate witness list. And then the defense will not update that list, and we'll be looking at going to trial in January.
Yes, Judge.
Okay, good. Okay, so Mr. Stevens, on this case, I'll see you back here no later than January 8th at 9 o'clock.
Okay.
I think that Rachel's got something. Okay, thank you, Mr. Koch.
Yes, thank you, Judge.
Other folks in the gallery, however y'all want to do that?
Judge, I have all of Mr. Klein's cases. Can I call them?
Sure. Whoever's in the gallery, if we can get them out of here first. Or on Zoom, don't forget Zoom.
Yes, sir. Emily Barber, I believe Miss Barber is on Zoom under a phone number.
Okay. Ms. Barber?
Mr. Kleins represents Miss Barber, and I believe this was placed on the docket based on a failure to appear on pretrial. Mr. Kleins has been in contact with her. It looks like they are attempting to move forward in the case, so we're asking the case to be continued until 1/8. Madam Clerk, since she's on the docket today, was there a capias issued in this case? Okay. I believe Mr. Kleins passed it over to today.
Ms. Barber, so make sure that you stay in touch with Mr. Kleins. I know he's out today, but stay in touch with him, and I will see you back here on January 8th at 9 o'clock, okay?
And Judge, Ms. Barber is on Zoom because she is ill and did not want to contaminate the rest of the courtroom.
And we appreciate that, Ms. Barber. We hope you feel better.
Thank you.
Thank you, Ms. Barber.
Monica Coronado, followed by Daniel Ledoux. Ms. Coronado is here in 20 CF 1108. This looks like a PTI recall, and my notes reflect that there's going to be a new PTI in this case, and that the parties need time to get that document together.
Okay.
So we request a continuance.
Thank you. Ms. Coronado, unless all the paperwork goes through before January 8th at 9 o'clock, I'll see you then. If all the paperwork goes through, then Mr. Kleins will let you know you don't have to be here on that day.
Yes, sir.
Okay? Thank you, ma'am.
Okay, he'll reach out to you and let you know.
Thank
okay?
you.
Daniel Ledoux. Mr. Ledoux is present. Judge, this is a case that is on the trial docket. It looks like there was an offer from the state. I believe that was placed on the record at pretrial. Mr. Ledoux wishes to continue forward with trial.
Okay. Is the state ready for trial on Mr. Ledoux's case?
That is correct, Your Honor. I believe that Mr. Kleins and I were talking about either Thursday or Friday of the first week.
Okay. So that'd be the 30th or 1st?
Yes, Your Honor.
Is it going to be a one-day pick and go?
That's correct, Your Honor.
Do you want to schedule it for one of those 2 days?
Judge, I'd ask for him to come back on jury trial review to make sure we hit all the moving pieces.
Okay. Mr. Ledoux, I'll see you on Wednesday in 2 days at 9 o'clock, and we'll schedule up that hearing, that trial.
Okay.
Thank you.
Okay.
Billy Lane. Followed by Brent.
Okay. He was. He's been blinking. There he is. He's here. Mr. Lane.
Picture, Your Honor. That's not actually, yeah.
Okay.
Mr. Lane, can you cut on your video? Jason McKinney for Scott Kleins and Mr. Lane's case, 23 CF 195. Mr. Lane, can you hear me okay? I'm not your honor. I'm your attorney. But the agreement that's been reached with the state, with Mr. Klein's, is that if you entered a plea, you would be placed on supervision for 12 months. That would be administrative probation. That would include a $50 administrative probation fee. You would have to check in with state probation to start the administrative probation, and there would be standard court costs of $515 and a $150 cost of supervision. That would be with an adjudication of guilt to a third-degree felony. Does that sound familiar to you, and is that the position that you wish to accept?
Yes, sir. I just have one question. It broke up momentarily there. That would be for time served?
That would be 12 months of probation, 1 year of probation.
Okay. I'm currently over in Pensacola Veterans Village. That's where I was transferred from 12 Oaks. And will that be able to complete, is that administrative probation? Is that something I can complete over the phone, or how does it work?
Yes, sir, that would be administrative level probation. Normally with administrative probation, you have to check in one time, but upon accepting this plea, you would contact state probation, and they would give you reporting instructions, since you are currently where you're at over in Pensacola. Oh, there he goes.
He's been blinking on and off.
And Your Honor, just for the record, I just want to make sure it's on the record, the reason why the state is agreeing to the admin probation is that because we have actually been provided a certificate of completion from 12 Oaks for Mr. Lane, and he has been taking steps to achieve sustained sobriety, and so we're trying to not impact those steps that he's making, which is why we agreed to the administrative probation.
Excellent, thank you. Mr. Lane, can you still hear us?
Yes, Your Honor.
Okay, if you'll start your video. I've just got a black screen. I need to be able to see your face to swear you in.
I'm seeing it on, there we go.
We still can't, there you go, good. If you'll raise your right hand.
Yes, Your Honor.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Lane, could you hear me?
Yes, Your Honor.
Okay, thank you. You can put your hand down. So, Mr. Lane, here's what I understand, is that, have you ever been adjudicated guilty of a felony before? Mr. Lane, I'm going to stop your video just where it may give us some more bandwidth. Okay, so, Mr. Lane, have you ever been adjudicated guilty of a felony?
Judge, he has.
Yes, sir.
Okay. Mr. Lane, I do accept your plea. You're adjudicated guilty. You're sentenced to 12 months administrative probation. You'll need to pay the one-time fee of $50. The court cost, in addition to that $50 setup fee for administrative probation, $150 public defender's fee. So you're going to give Mr. Lane the telephone number?
Yes, Judge. And I was inquiring about cost of supervision. Did the court seek to impose cost of supervision in this case, given he's in a treatment?
I thought it's a one-time administrative fee for admin.
Just wanted to make sure.
Yes, sir.
And state probation, what would be the best phone number for him to reach who he needs to reach? 850 344 0005. Mr. Lane, did you get that?
Mr. Lane, could you hear? Hello, Mr. Lane. I stopped his video, I think, intentionally to try to give more bandwidth. Let's try it again. Mr. Lane, can you hear us? He's coming back. Mr. Lane. Hello, Mr. Lane. Transcript's going to look really good on this.
It's going to look excellent, Judge.
Hello, Mr. Lane, can you hear us? Okay, Mr. McKinney, you'll just have to let Mr. Lane know what that telephone number is.
I will do so, Judge. I'll have my office reach out to Mr. Lane to make sure that he calls to start the administrative probation.
Okay, sounds good. Thank you.
I can't say his last name, so I'm going to have him say his last name.
Okay,
Lukaszewski.
thank you, sir.
Judge, he is present. In 23 CF 510, we have an agreement. I've reviewed the agreement, which calls for a plea as charged and adjudication of guilt. He has been previously adjudicated guilty. It is a time-served agreement, no probation, $615 in court cost, $150 cost of defense. May I approach with the plea agreement?
Yes, sir. If you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. If you'll please state your full name and date of birth.
Brent Lukaszewski, 7/10/70.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You'll need to pay the court cost, the $150 public defender's fee. How long will you need to pay? About $800.
30 days.
Okay, yes, sir. If you fail to pay it within 30 days, then it will go to a civil lien or judgment. Thank you, sir.
You're going to get fingerprints over there. And Judge, may we jump to my case, Christian Viljoen?
Sure.
Mr. Viljoen is present in the courtroom in 22 CF 1382. Judge, I've been in communication with the state, Ms. Davis, on this case. It was left on the trial docket. However, we anticipated that there would be some moving pieces related to actually trying this case this cycle. So at that point, I'll reach over and pass it to the state.
Judge, at this point, we're going to request a continuance for the trial from this month. We have, as Mr. McKinney said, had some communications. We are working on a resolution for the case that may result in not going to trial on the case. So there's just some inner workings that need to be done to make sure that we're clear with where we're at.
Okay.
And we can make that a joint continuance, Judge, given that there are witnesses on both sides. I echo the state that we are moving forward and hopefully towards a resolution here that we might be able to do in December. Otherwise, when we come back in January, if we're still here without an agreement, then we would be ready for trial.
Good. So what I've written down is trial next times ×2, and so I'll really be pushing both of the parties to go forward with a trial in January if it's not resolved prior to that. I'll see you back here no later than January 8th at 9 o'clock.
Yes, sir.
Okay, thank you, sir.
Yes, sir.
Judge, that's all I have before you today, if I can.
Yes, ma'am. Thanks, Ms. Davis.
Jonathan Lynn with Mr. Kleins.
Mr. Lane, can you hear us? Mr. Lane? Nope. Okay. Yes, sir.
Just as Jonathan Lynn before the court. Mr. Lynn is represented by Mr. Kleins. And it looks like this was passed over for communication with the state, and they were trying to resolve the matter. Without a plea agreement in hand, my intention is to likely ask for a continuance unless the state has an offer to make Mr. Lynn.
No, Your Honor, we had gotten back the FDLE amount, but we're trying to get the specific substance weighed. There was multiple groups of substances, and so we got the FDLE back that confirmed the substance. Now we're just trying to get the weight on it.
Okay.
So we were just, I think a one cycle continuance is best on this case.
So state's motion for continuance?
That's okay, Your Honor, yeah.
Mr. Lynn, I'll see you back here no later than January 8th at 9 o'clock.
Yes, sir.
Thank you, sir.
Be sure you reach out and talk to Mr. Kleins, because I know that he's going to want to give you some updates to maybe try to resolve it earlier than that. Okay.
Thank you.
Hillary Marion. Hillary Marion is 23 CF 793.
I don't see Ms. Marion.
Your Honor, at this time, the state's going to be announcing a dismissal of this case based on the specific request of the victims to dismiss this case.
Okay. Ms. Marion's case 23 CF 793 is dismissed.
Antonio Marshall, followed by Aaron Martinez.
Antonio Marshall. Hello, Mr. Marshall.
Mr. Marshall is present and approaching 23 CF 1586. He has signed a plea agreement for a misdemeanor. Count 1 would be reduced to resisting without violence and with an adjudication of guilt. Count 2 would be plea as charged. The terms of the probation here are a 1-year probation on each count consecutive for a total of 2 years supervision, 24 hours community service work in each count. And then that is consecutive as well. In count 2, the firearm would be forfeited. There would be standard court costs with a $150 cost of defense. May I approach with that misdemeanor plea agreement?
Yes, sir. Thank you.
And that would be JCS probation, and I provided JCS contact information to Mr. Marshall.
Okay, thank you. Mr. Marshall, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Marshall, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
He did.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
I did.
Mr. Marshall, I do accept your plea. You're adjudicated guilty of the misdemeanors. You're sentenced to 1 year probation in each count to run concurrently for a total of 2 years. You'll also need to perform 24 hours of community service work in each count, so that's a total of 50 hours. The subject firearm is forfeited. You'll need to pay the court cost, $150 public defender's fee. Since JCS is the one that is doing the probation, it's $50 per month cost of supervision. Thank you, Mr. Marshall. Good luck to you, sir.
And you've still got their contact information? Okay. Aaron Martinez would be next. Mr. Martinez is present 23 CF 272. We've reached an agreement. Mr. Martinez would be entering a plea as charged. In count 1, adjudication would be withheld. Mr. Martinez will be placed on 2 years of state probation.
Okay, wait, hold on. Make sure this is Aaron Martinez?
Correct.
Got it. Yes, sir. Okay.
Mr. Martinez would be entering a plea to, as charged. In count 1 would be 2 years probation with special conditions, substance abuse evaluation within 30 days, treatment to begin within 60 days, 24 hours community service. Counts 2 and 3 are misdemeanors. They would be adjudications of guilt to the misdemeanors and time served. $615 in court cost, $150 cost of defense. It's specifically written into the agreement that Mr. Martinez may request early termination after 12 months if he has successfully completed all of his conditions and he has not violated the terms of the probation. May I approach with the plea agreement?
Yes, sir. Thank you. Mr. Martinez, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Martinez, did you read the plea agreement?
Yes, sir.
Do you understand it?
I do.
Did you discuss it with your attorney?
We did.
Did he answer all of your questions?
He has.
Are you satisfied with his representation?
I am.
Did you sign the plea agreement?
I did.
Mr. Martinez, I do accept your plea. You're adjudicated guilty in counts 2 and 3, the misdemeanors. Adjudication is withheld on count 1. You're sentenced to time served on the misdemeanors, 2 years probation on the felony count. You'll need to submit to a substance abuse evaluation within 30 days from today. If any treatment's recommended, begin that within 60 days from today. Perform 24 hours of community service work, pay the court cost, $150 public defender's fee, and also $40 per month cost of supervision. Thank you, sir.
Thank you, Your Honor.
Your Honor, did the defense provide a score sheet?
No,
Did
sir.
not.
Okay, we will provide a score sheet at a later.
Mr. Lane, we're finished with your case, Mr. Lane. And we lost him again. Okay. Okay. Mr. McKinney, who's next?
We have Yerlin Martinez Hechevarria, who is present on Zoom.
Okay.
Sir, could you please start your video? This is case number 22 CF 2480.
Yes, sir. Mr. Martinez, if you'll start your video and take your mic off mute. Mr. Martinez? Okay. He hadn't done that yet, so you want to...
Yes, sir. I have Terry McMullen, who's present in the courtroom.
Okay, thank you.
And he pressed a button, just not the right one. Commissioner McMullen is here in 23 CF 250. Judge, this is a plea agreement as charged that calls for an adjudication of guilt and negotiated downward departure sentence, which would be 20 months Department of Corrections with credit for all time served, and $615 in court costs, $150 cost of defense. The intention of the parties here is to enter the plea and come back for an imposition of sentence on the 11th of December. So I know that the court would normally want to see the score sheet and everything prior to sentencing someone in the Department of Corrections. So we don't want pronouncement of the sentence until, no, but that's something that would be no problem. That's no problem. Because I know that once the court announces a DOC sentence, that's
right.
what it is. So
Yes,
I wanted
sir.
the court to be aware of the plea agreement. May I approach?
Yes, sir, thank you. Thank you. Mr. McMullen, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. Mr. McMullen, I'm smiling because I think of the foundation that other similar defendants have laid for you. They have appeared when they were supposed to appear for their sentence in prison. If I had a lot of defendants that didn't do that in the recent past, I'd probably say, nope, I'm not going to defer a sentence. You guys go back and talk. But since they've done that, so I hope that you'll continue that when you show up. Okay.
He's saying,
Mr. McMullen, if you'll please state your full name and date of birth.
Terry Lee McMullen, 3/26/1971.
Mr. McMullen, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness
No,
or
sir.
emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
8th grade.
Okay. Did you read the plea agreement?
I did.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
I did.
Mr. McMullen, I do accept your plea. So I will see you back here on December 11th at 9 o'clock, okay?
Okay, sir.
Thank you, sir.
Thank you.
yes, sir. Louis Morant,
Okay,
unless the
hold
court
on
wishes to
one sec.
recall.
Yeah, Mr. Lane, can you hear us? Mr. Lane's still frozen. Nope.
Yep.
Mr. Martinez, if you can unmute your microphone and start your camera. Mr. Martinez? Almost. There you go. Good, Mr. Martinez. Yes, sir, we can hear and see you.
Yeah, look, it did lock me off.
Judge,
Multiple times.
Okay.
Mr. Martinez, this is Jason McKinney in the courtroom. I'm standing in for Mr. Scott Kleins today. This is a case that is set on the trial docket. And the notes that Mr. Kleins have left me and the discussions I've had with the state are to leave this case set for trial.
Okay.
That's correct. And Your Honor, in this particular case, the victim is out of state. I have discussed with Mr. Kleins a specific date, and we would like to go ahead and make sure that we have that date reserved for this trial.
Okay, what is the date?
That is Monday, December 4th.
Okay. Yes, sir.
And it would be a pick and go. I would want to wait until Wednesday to give you an amount for that panel of individuals so that I can speak with Mr. Kleins. But I do know for certain that Mr. Kleins and I have both agreed to try the case on the first Monday of the second trial week.
Okay. So we need Mr. Martinez here on Wednesday? Or just, since we're scheduling it, I can just tell him 8:30 on Monday,
Yeah.
December 4th.
I think I'm okay with that. It's my understanding that Mr. Martinez is approximately 8 hours away. So I don't, unless Mr. Kleins wants him here, I don't personally need him to be here on Wednesday. I would just want him to know that he absolutely has to be in court on Monday, the 4th.
Much like today with Mr. Martinez appearing via Zoom so that he doesn't fall off the docket for Wednesday, I would like him to be on the docket for Wednesday for jury trial review. As to whether or not Mr. Martinez needs to be here in person, I have no notes from Mr. Klein saying that he needs to be here in person, so we
Okay.
will defer to the court.
So, Mr. Martinez, you need to appear Wednesday in 2 days via Zoom at 9 o'clock But I'm also putting you on notice that if something happens and Zoom doesn't work on Wednesday, you still have to be here Monday, December 4th at 8:30 a.m. So 8:30 a.m., December 4th, because we'll pick a jury and then go to trial that day.
Okay.
Okay.
And I have a question.
Yes, sir.
I was trying to reach Mr. Kleins and he didn't answer, so I don't know.
Mr. Kleins is currently out of the office, Mr. Martinez, but he can certainly talk to you over the phone. I'll leave some notes for him to call you as soon as possible. Have you spoken to his assistant?
Hello?
Hello?
Can you repeat that again?
Yes, sir, Mr. Martinez, we can.
Mr. Martinez, can you hear me better if I'm standing right here?
Right there, I swear to it,
I'll leave some notes for Mr. Kleins to reach out and talk to you, but you'll be here via Zoom on Wednesday.
Okay.
Mr. Kleins should be back by then, and he should talk to you before that date. And then your trial is scheduled for December 4th, and you need to be here physically in the courtroom by 8:30.
Okay.
Okay?
Thank you.
All right.
Thanks, Mr. Martinez. Mr. Lane, can you hear us? Mr. Lane?
Mr. Lane, can you hear us any better? Mr. Lane?
He's just got a bad signal.
Yes, sir.
Yeah.
And when I get a moment, I'll try to have my office reach out to Mr. Lane.
Okay.
Because we do have a phone number. Louis Morant. Is 23 CF 1182. It looks like that there is a waiver on file for Mr. Morant and that they are trying to get him into Veterans Court.
Okay.
It looks like a misdemeanor DUI in which Mr. Morant is represented by Mr. Chris Garrett. It looks like it's the holdup to get him into Veterans Court. And it looks like they are still trying to move down that path if we ask for a continuance to 1/8.
It's continued.
Mariah Mott. Ms. Mott is present in the courtroom. She's approaching.
Hello, Ms. Mott.
This is 22 CF 1620. It looks like they have received FDLE, and that Mr. Kleins wishes to depose the FDLE expert, and he has instructed me to request for a continuance until 1/8.
Okay. Any objection from the state?
We have no objection, Your Honor. I think in speaking with Mr. Kleins, both of us were anticipating a trial next time to be able
Yes,
to
sir.
resolve that no matter what next cycle.
Okay. Ms. Mott, I'll see you on January 8th at 9 o'clock.
Thank you,
Thank you,
Your
ma'am.
Devin Morales. Followed by Tristan Oya. Judge, this is Mr. Morales before the court, and it looks like they had left this on to try to resolve the matter. It doesn't look like they were able to, so I'm going to request a continuance until 1/8.
Okay. Mr. Morales, I'll see you January 8th at 9 o'clock.
It's actually on my birthday.
Is it? Okay.
But Mr. Klein's notes are that he's trying to resolve this ahead of your birthday.
I'm sorry.
So,
I
I mean-
don't mind it being on my birthday. It's just another day.
Okay, so
I
be
just
sure
thought
you,
it was funny.
be sure you talk to Mr. Klein's, because if they're able to resolve the matter, then it would be a lot easier to do that on a December date than a date on January where there's a ton of people in the courtroom.
Okay.
Okay?
Thank you, sir.
We have Happy New Year.
Mr. Oya is here in 23 CF 419.
Morning, Your Honor.
Morning, sir.
We've reached an agreement. The agreement calls for a misdemeanor reduction to a misdemeanor trespass for an adjudication of guilt, standard court cost, $150 cost of defense. That would be administrative level probation with JCS. We would be reserving over the amount of restitution for a period of 90 days. May I approach with that misdemeanor plea agreement?
Yes, sir. And how long is supervision?
12 months.
Thank you. Thank you. Mr. Mr. Oya, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Oya, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
He did.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
I did, yes, sir.
Mr. Oya, I do accept your plea. You're adjudicated guilty of the misdemeanor. You're sentenced to 12 months probation. That'll be with JCS. They charge $50 per month. It's administrative probation. You'll need to pay the court costs, $150 public defender's fee. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution.
Yes, sir.
Okay? Thank you, sir. Good luck to you.
Thank you, sir.
And Judge, and I provided the contact information for JCS for Mr. Oya to contact.
Good.
Yes,
Thank
sir.
you.
Okay.
Mr. Lane, can you hear us?
Good, sir.
Yes, yes, Your Honor.
Good. Tell him quickly the number. Hold on one second, Mr. Lane. Everything's done, but nope.
I
Nice
wasn't
try.
quick enough, Judge.
Gotta be fast.
I wasn't quick enough. Crystal Owen. Crystal Owen. And Crystal. I have a Crystal and a Carolyn.
So, Your Honor, hold on. Can we approach on
Crystal?
Ms. Crystal Owen?
Yes.
Okay, yes, sir.
Inflatable amusement company, recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
In her file. It looks like it still needs to be set for a hearing date.
Yes, sir.
In learning that, I would request a continuance, and I know that Mr. Klein's office will work on setting that for a hearing.
Okay. Ms. Owen, do you agree to the continuance?
Yes, sir.
I'll see you back here on January 8th at 9 o'clock, unless they set this motion hearing before that date.
And I believe that is the intention, so be looking out for a phone call from Mr. Klein's or his office.
Yes, sir. Thank you.
Thank you, ma'am.
There's an Arnold Pennell that I believe a waiver was filed related to a PTI, but I believe it's on this docket. So I'm requesting a continuance because it looks like they are just trying to get all the paperwork where it needs to go.
Okay, yes, sir.
And I believe that's all I have that are out of custody.
Okay, so everybody else is waiting for an inmate?
I see some individuals on the docket for Mr. Koch.
Can you
so
grab
I
him?
can endeavor to find Mr. Koch right quick.
That'd be great. Thank you.
Judge, he is in the attorney-client room, and he is coming immediately.
Good, thank you.
I believe the remaining cases I have are all incarcerated for myself and Mr. Lyons.
And Rachel's asking who's in the gallery, who they're waiting for, or we can take them sooner than later.
There is a matter on the docket two matters I can call.
Please.
Fred Vick. Judge, I represent Mr. Vick in 23 CF 2082 and 23 CF 2083. In both of those case numbers, the court let me put this on for docket day because Mr. Vick did not appear at pretrial. So I've sounded the courtroom today in trying to find Mr. Vick.
It was noticed for 9 o'clock. It's now 11:44. A no bond capias will be issued for Mr. Vick.
And Judge, I also have Malkia Turnage, which is 23 CF 237, which is on the trial docket. This is an individual where the court did have a motion in limine hearing, and at that point in time, the court instructed that Ms. Turnage on Zoom that she needed to appear in person on jury trial review. She normally appears via Zoom because she lives in Atlanta. So I would ask the court to keep this on track for trial with the anticipation of seeing Ms. Turnage in person on the 22nd.
Okay, so,
West Capias?
okay. Has the state have you issued subpoenas?
Them out, yes, sir.
You did? Okay. I'm not going to issue the capias at this point, so I'll see her in 2 days. If not, then I will issue a no bond capias.
Yes, Judge.
So I've got it for trial.
Yes, sir.
Mr. Lane, can you hear us? Hello, Mr. Lane?
Can we approach?
Certainly.
McKinney and I?
Sure.
On
Okay.
this.
I don't know if I'm doing harm than good, but I'm going to exit.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Mr. Pybus in 23 CF 1335. This will be a change of plea, Your Honor. No contest plea. Be adjudicated guilty, 3 years probation, $615 in court cost, $150 in defense costs, the substance abuse evaluation within 30 days, any recommended treatment within 60 days, random year analysis, and 30 hours of community service. If I may approach.
Yes, sir. Pybus, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Pybus, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Absolutely.
Did you sign the plea agreement?
Yes, sir.
Mr. Pybus, I do accept your plea. You're adjudicated guilty. You're sentenced to 3 years probation in each count to run concurrently, run at the same time. You'll need to pay the court costs, $150 public defender's fee, $40 per month cost of supervision. Submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today.
Yes, sir.
Submit to random urinalysis and perform 30 hours of community service work. Thank you, sir. Good luck to you. Okay, because they had it down as 5 years. Time served on count 2.
That's correct, Your Honor.
Okay. You had 5 years down for count 2.
It's a misdemeanor. It was not more than 20.
Oh, gotcha.
Mr. Pybus, just where I'm not laying awake tonight worrying about this, on the plea agreement, it showed count 2 as a felony. It was a misdemeanor. So, do you understand that? It showed you on the plea agreement. Here's the reason why I'm asking you, is if you say, dang, Judge, I thought both of those were felonies, that's the only reason why I entered the plea. I wouldn't have entered it if I would have known that count 2 was a misdemeanor. Okay, you understand it was a misdemeanor, and you still want to enter the plea? Well, it would be the exact same sentence, but I just wanted to make sure. Again, I don't want to do a bait and switch on you where you think you were pleading to 2 felonies when one was a felony and one was a misdemeanor. Okay, thank you, sir. Okay, yes, sir.
Thank you, Judge. This is Daniel Peterson, 2023 CF 731, Your Honor.
Yes, sir.
And we'll plead to the lesser for simple battery and Florida Statute 784.03, Your Honor. And this will be a 1-year probation, adjudicated guilty, 270 in court costs, 150 defense costs, 24 hours community service, no contact with Jamie Lorenz, and restitution for 90 days, Your Honor, if I may approach.
Yes, sir. Thank you.
And then also, Your Honor, after we enter a plea, my client does wish if he could possibly perform community service for the court costs.
Okay. Yes, sir. Mr. Peterson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Mr. Peterson, did you read the plea agreement?
I did.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
I did, sir.
Did he answer all of your questions?
He did.
Are you satisfied with his representation?
I am.
Did you sign the plea agreement?
Yes, sir.
Mr. Peterson, I do accept your plea to the lesser included offense. You're adjudicated guilty. You're sentenced to 1 year probation. You need to pay the court costs, $150 public defender's fee, perform 24 hours of community service work, have no contact with Jamie, Jamie, Lorenz, Lawrenz. Court does award restitution, but reserves jurisdiction to determine the amount of that restitution if the state files a motion or a petition within 90 days from today. You'll also need to pay the $40 per month cost of supervision. Thank you, Mr. Peterson. Good luck to you, sir.
And, Your Honor, if possible, could we address performing community
And you
service?
can certainly pay off the community service work if you wish to.
Inverse. I wish to see if I could pay court costs with community service. I'm unemployed.
You can pay off any costs that are allowed to be paid off by community service. Yes, sir.
Okay.
Can't tell you whether court costs can do that, but you can work off any other costs. Yes, sir.
All right. Thank you, Your Honor.
Thank you.
Robert Petty, Who's present approaching, Your Honor? This is 23 CF 642.
How you doing, sir?
Good, how are you?
Pretty good.
Good. Yes, sir.
Judge, this will be a change of plea of no contest. This will be to the lesser included. The fleeing.
I'm sorry, what's your last name?
Petty, P-E-T-T-Y.
Great, thank you, sir.
Yes, sir.
Yes, sir.
Yes, Your Honor. It'll be no contest plea to the lesser included of the F3 fleeing or attempting to elude a law enforcement officer. And this will be adjudication of guilt, 3 years probation, $515 in court costs, $150 defense costs, 50 hours community service, and a 1-year driver's license revocation. If I may approach.
Yes, sir. Thank you. There's a 2-count information, yes. You want to talk to the state?
Yes, please.
Mr. Nopes, what are you back for?
Judge, I'm still waiting on Mr. Lee to get here. He's walking.
Okay. Yes, sir.
So I showed that information was filed for the Flynn Lee on 119. The investigation was filed on May 30th, which added the DUI. Case number 23CP760 was transferred into this case, which added the DUI.
Let's just set this off first.
Judge, speak with the state. If we could continue this to the 1-8 pretrial, I guess there's a DUI out there that needs to be addressed.
Okay. Mr. Petty, I'll see you no later than January 8th at 9 o'clock, but if they figure out what's going on and you want to accept it before that date, Mr. Koch can set a hearing next month, okay?
Okay.
Thank you, sir.
Awesome, thank you so
Thank
much.
you.
I'll call you. Yeah, absolutely.
Judge, next case would be Natalie Pearson.
Thank you.
And this is it's a PTI offer, Judge, that defense is going to accept. We're just getting the contract sent over. If we could put this on the 1-8 pretrial just for a backstop.
This is Natalie Elizabeth Pearson?
Yes.
No.
Oh, I got two, I called Natalie Pearson, but we can address Mr. Dexter Pearson.
Okay, good. Mr. Dexter, I was wondering. Okay.
Your Honor, I think just so I need to just corroborate, there has been a drop charge request filed by the alleged victim in this case. I haven't had the opportunity to actually reach out myself and speak with her just to make sure that we cover all our bases with regards to that drop charge statement. If we can just set this for maybe December 14th, not all the way to 1-8, but just December 14th, it's incredibly likely that it will fall off the docket before then.
What about, and I don't know if y'all really do this much, you don't, I haven't seen you file dismissals without a hearing, but you could always do that, I would think.
Yes, Your Honor. I've filed null process without hearings and stuff like
Okay.
that. I just need time to make sure that I.
So instead of making everybody come back, what about if we just continue it until January 8th, and then if you want to file a null process?
That works, Your Honor.
Okay. So I'm setting your case for January 8th at 9 o'clock, but hopefully the state will, if they decide to file a null process, they'll address it before that date, okay? So stay in touch with Mr. Koch.
Yes, sir.
Thank you, sir.
Yes, Judge. Now if we call Natalie Pearson.
Okay, Natalie Pearson?
And Judge, this is a PTI offer that my client accepted. We're just getting the contract sent over. If we could put this on the 1-8.
Okay, yes, sir, it's continued.
That Ms. Tommy Ross, who's present and approaching, Judge. And, Your Honor, There's two cases. So for 22 CF 1386, I believe the state is going to announce a no pros.
On Ms. Ross.
Yes.
Hello, Ms. Ross.
Hello.
So, Your Honor, in 2022, CF 1386, the state would announce a no pros. It looks like she has completed the mental health program, so. at
Okay,
this point,
so that case is dismissed.
Yes.
What about the other case?
Yes, Your Honor. I requested to put this with this case just in case we want to resolve this one. In the 23 CF 2063, this was a first time up. I'm seeking a continuance to put it on that 1/8 docket.
Okay. Ms. Ross, I'll see you back here on January 8th at 9 o'clock, okay?
Okay.
Thank you, ma'am.
Thank you.
You're welcome. Judge, next case would be Cheryl Rubin. And if you recall, for pretrial, this was my client, Marilyn. The alleged victim is deceased in this matter. We just set it for today. The state did, I spoke to them on Friday. They're going to move forward with the charges, but there is a deposition from that alleged victim. I believe it's in an insurance matter, a non-criminal case that they're going to prove the case on. Of course, I haven't seen or heard that deposition.
So a continuance?
That's what I'm seeking, Judge.
You got it.
And Judge, that's all my out of custody.
Okay, thank you. You got a gentleman in the back raising his hand?
Oh, I'm sorry. Joshua Phillips, Judge.
Thanks. Mr. Phillips, come on down.
That's right.
Got it.
Judge, I believe this was a graduate from the mental health program, so it was a late add-on. I'm seeking if we could put it back on our docket for the 1/8
Okay.
pretrial.
Mr. Phillips, I'll see you back here on January 8th at 9 o'clock. Okay.
Yes, sir.
Thank you, sir.
All right.
Judge, now that is all my out of custodies.
Okay. Mr. McKinney?
Because I have no more individuals
Okay.
who are in the gallery.
Rachel?
I do have family that's here for an
Right,
inmate.
and I think Rachel's got their names, so you've got the docket?
Are any of those with Mr. Klein? And Mr. Tyler, number 41. He's not up here yet.
Mr. Koch, they're bringing the inmates in.
Yes, Judge.
Judge Hayward Reeves with Mr. Koch.
Thank you.
Their parents. Yeah.
Yes, sir.
Yes, Judge. I believe this was an add-on from mental health court. May I just have a brief?
Certainly.
Judge, I'm requesting we set this on the 1/8 pretrial date.
Okay. Mr. Reeves, I'll see you on January 8th at 9 o'clock. If the state offers you something that you want to accept before then, Mr. Koch can set you for a hearing next month.
That's even if the victim's here on my behalf to drop the charges. They've already dropped charges.
It's up to the state to decide whether they drop the charges or not. I can't make the state drop charges. Thank you, sir.
Stephen Rogers.
Thank you. Hello, Mr. Rogers.
Sir?
Yes, sir.
Yes, Your Honor. We set this so my client could be here in person. Your Honor, I am requesting a continuance. There's outstanding discovery. We still need body cam. This was the first time up on our last pretrial. My client, via Zoom, requested that he may want to remove me and move forward for trial, so that's where we are at this moment.
Mr. Rogers, when I was doing my homework and I looked back and I put plea trial, which is what I announced back then, and I put very insistent that you
Yes, sir.
really wanted to go to trial.
Yes, sir.
So, do you still want to be represented by Mr. Koch?
Not really.
Okay. Do you think he's rendered ineffective assistance of counsel to you?
3.850?
Yes, sir.
Yes.
Okay.
I haven't seen him in 60-something
Okay,
days.
hold on. If you'll raise your right hand.
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. Tell me what the facts are that would support that.
I haven't seen him in 60 days. He said it on September 14th that he would be up on Friday to see me. I haven't seen him since then, since we were standing at the podium on September 14th, on top of which he said that I had a mental health eval for the bars to bed rehab with Bridgeway, the 90-day inpatient. I haven't seen any of them. I still don't know my diagnosis from my mental health eval that I did complete all secondary things, what did y'all call them? Conditions, secondary conditions with the probation, the drug eval, and the mental health eval.
Okay.
I don't know the results of that. I went to the Pattison group in meditation on Vine Street.
Yes, sir.
I was supposed to talk to Miss Rebecca again the day before my...
Okay, but let's focus on
Yeah.
Mr.
Okay.
Koch.
Other than that, he didn't have I still don't know the offer from the state. My goal was to beat the new law violation and then, of course, handle the VOP after the new law violation was completed, is the attended. I want to go to trial because this is ridiculous.
Let's see if I can get on my calendar on this one.
Yes, sir.
I'm not overly optimistic. Okay. Mr. Rogers, what other evidence would there be of ineffective assistance of counsel of Mr. Koch?
I asked him what the deal was last time. He still hadn't had a confirmed deal from the state. I asked him my points. He didn't know that either. There was several. I didn't expect this. I would have wrote it down and rehearsed.
Let me see if I can call up the docket. Or, yeah, the docket on this. Since our computers were compromised, it has certainly made it more challenging.
There's been several attempts with my fiance Jamie to get in touch with him to put it on record to meet up with him because he needed to speak with her about 1804.
Okay.
And still, she's emailed him, she's called, the assistants won't divulge, and there has been no meeting with, so.
Mr. Koch, as far as the mental health, was there a mental health evaluation that was done?
Negative, Judge.
Because that's, you know, whenever I hear that, then I'm like, has that been ruled on? And I don't see it, at least on the docket on one of the cases.
On my probation, sir, on the previous charge of 13, I can't remember what I was on probation. The one that I'm on probation for, the violation of probation.
Okay.
You resentenced me to drug offender probation, followed by a year of probation, followed by a mental health eval with a drug eval, and a 7 o'clock curfew.
A mental health evaluation. Okay.
Yes, sir. I
Okay.
did all of that.
Judge, not to interrupt, but I don't want my client possibly talking about the DOP that's out there.
Understand. Okay. So, Mr. Koch, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you so. Mr. Koch, what I wrote down was he hasn't seen you since September 14th. Talked about the mental health evaluation. Doesn't know what the offer from the state is.
Yes, Judge. My client does have a VOP and a new law. Not to get to my discussion with my client, but that new law, the body cam and full discovery is important for that case, and we still haven't received it. And this was the first time up for pretrial on 11/13, so it wasn't like the state's been lagging on it, it's just the first time up. So that's why I was seeking continuance. There is a 72-month DOC offer, Judge, but I was just waiting for full discovery and then to go over with my client.
Okay, so why haven't you met with your client since September 14th?
Judge, if I could just have a moment. We just from the first meeting, Judge, I was waiting for the discovery to go back and meet with him at the Crestview jail.
Mr. Rogers, 2 months is a long time to be in jail without talking to your attorney.
Yes, sir.
Your motion for ineffective assistance of counsel is granted.
Thank you.
So I do appoint the regional conflict counsel to represent you.
Thank you.
And the public defender is discharged. So I'm going to set your case for January 8th at 9 o'clock. Ms. Jakewood should come see you before then.
Can I push for the speedy trial, or do I have to wait for counsel?
You're represented by counsel, so you need to talk to her.
Okay.
Okay.
And my VOP doesn't have a bond, and you're the only person to set the bond on the VOP?
Ms. Jakewood, you'll need to talk to her about that.
Set a bond hearing?
Yes, sir, correct.
Thank you.
Thank you.
January what?
January 8th.
Thank you, sir.
Thank you, sir.
God bless.
Sean Baxter Williamson.
Thank you.
Judge, I wanted to know if Mr. Lee's here, and I'm covering the plea agreement.
Absolutely. You let me know when you're ready.
Okay, thank you, Judge.
Thank you, Mr.
Any
Daly.
questions we talked about? I'm just gonna have these. Judge, if I might have a moment just to sign.
Sir.
Right there. At 11:20. Okay.
Sean Sasser Williamson.
Thank you. Got it. Thank you. Mr. Cox?
Yes, Judge, this will be a change of plea. We have case number 2023 CF 381 and 2023 CF 411. Those are both count ones. This will be a withhold of adjudication. It'll be the 6 months Okaloosa County Jail, followed by 5 years of probation. All counts to run concurrent. Best efforts to obtain a GED, substance abuse evaluation, and any recommended treatment. There's 50 hours of community service. Reserve on the restitution. Letter of apology to Sandra Williamson. No alcohol, no drugs without a valid prescription. Random year analysis. Random breath test. Must complete a mental health evaluation with any recommended treatment. Court costs of $1,030. Defense costs of $250. And then in case number 2023 CF 1472, count 1, that's going to be the lesser included of reckless driving misdemeanor. He will be adjudicated guilty, 6 months of probation to run concurrent, court costs, the advanced driver improvement course. In that case number, there's 95 community service hours, the victim impact panel, and $100 cost of defense. And lastly, Judge, the 2023 CF 1472, count 2 and count 3 will be no cost. If I may approach with the plea form.
Yes, sir, thank you. Thank you, sir. So let me start with that. Counts 2 and 3 are dismissed. Mr. Sasser Williamson, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Sasser Williamson, I do accept your plea. Adjudication is withheld. You're sentenced to 6 months in the Okaloosa County Jail with credit for all time served.
Yes, sir.
All of these sentences are to run concurrently, run at the same time, followed by 5 years of probation. You'll need to do, when your attorney stated best efforts to get your GED,
Yes, sir.
I think of how many hundreds of times I've had someone standing in a lectern where you're standing.
Yes, sir.
And I ask the ones that are going to prison, and I say, how far did you go in school? And I can answer that question before they even start saying anything the majority of the time, because their head drops if they haven't graduated or gotten a GED. And when they've gotten their GED, their head's up. I congratulate them because it's self-motivated. Just an observation from the court. So you'll use your best efforts to obtain that degree. It's the best for you, best for society.
Yes, sir.
You'll need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. Perform 50 hours of community service work. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution. You will need to do a letter of apology, have no alcohol, no drugs without a valid prescription. You'll submit to random breath test, random urinalysis. You will need to submit to a mental health evaluation within, and before I think I said 30 days, let's do 45 days for the substance abuse and 45 days to submit to the mental health evaluation because of the holidays. You'll need to pay the court costs, total of $250. Well, is it really? Yeah, $250 in public defender's fee, $40 per month cost of supervision. In the misdemeanor case, it's 6 months. Probation, that's to run concurrently. Take the advanced driver's improvement course, perform 95 hours of community service work, enter and successfully complete the victim impact panel, and then the court costs for that case. Thank you, sir. Good luck to you.
Thank you, Bob.
One more thing, I don't know if you want to take this notes first.
Okay. Mr. Nopes, you ready?
I am, Your Honor.
Good, please.
Your Honor, may I approach?
Yes, sir. Thank you, sir. Mr. Lee, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, sir. You can put your hand down. Mr. Lee, where'd you walk from?
Right off of Hollywood on Carson, the very back of Carson.
Yes, sir. New Chick-fil-A's back there, right?
Is it?
I think so, on part of Carson anyway. The reason why I asked that, Mr. Lee, is I have folks that give an excuse of I couldn't get a ride, and they're on Racetrack Road or somewhere else. I had one, I think it was a man that walked from Navarre here for a hearing. And so whenever somebody says, I couldn't get a ride, and I think about that guy walking from Navarre. So thank you a lot for doing that.
No, not a problem. Sorry I was late, Your Honor.
I appreciate you being here. So, Mr. Lee, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir, I did.
Mr. Lee, I do accept your plea. Adjudication is withheld. You're sentenced to 3 years of probation. You'll need to pay the court cost, $150 public assistance fee. You need to pay restitution in the amount of $8,529. Who's that in favor of?
State of Florida, I believe, right? AJ?
Your supervision, when it says, okay, it's an automatic supervision, okay? If you fulfill all the terms of your supervision and don't commit any new law violations, then your supervision will automatically terminate, okay? That includes the payment of the restitution.
Yes, sir.
Oh, I'm sorry.
Do we know that?
I believe it's the Florida Department of Financial Services, Your Honor.
Okay. Yes, sir. Thank you. Thank you, Mr. Lee, and again, thank you for walking over.
Judge, I'm not sure if I wrote it up correctly, but upon payment of the restitution and no violations and the court cost and a $150 public assistance fee for court-appointed legal assistance fee, that once he pays those dollars, then it terminates automatically.
Yes, sir, because I don't think he has any other requirements other than that.
Judge,
Correct.
we would ask that you consider waiving this cost of supervision because he's making that big restitution.
Mr. Lee, how much money do you average making per month?
Per month, around maybe 1,500 right now.
Okay.
Kind of
Mr. Lee, I do waive the cost of supervision. Okay.
Thank you, Your
Mr.
Honor.
Adams.
Thank you, Judge.
Mr. Lee.
Thank you.
We have Jordan Towery and Mr.
Judge, this is Jordan Towery before the court in 22 CF 1766. This is on the docket, plea or continue, because there's been negotiation between Mr. Towery and the state that had some expiration dates on it. The state had made an offer to Mr. Towery that was reduced from what we'd previously been discussing. I reviewed that with Mr. Towery. I met with him yesterday at the jail. His family is present in the courtroom. I know that there's been a lot of discussion related to Mr. Towery. That's giving the court a window into where we're at with it. I'm going to be requesting a continuance, but I would ask the state to leave the offer open until December 11th before withdrawing the current offer, of which is 6 years Department of Corrections followed by 4 years of SO probation. I would ask for a status hearing on the 11th of December for any revocation of the offer for Mr. Towery to enter a plea.
To the state?
Judge, this was just set as a status date. We would have no objection to leaving the offer open until then, but it will be revoked on the December 11th date.
Okay. So, Mr. Towery, first off, your underlying case will be continued until January 8th at 9 o'clock, but I'm setting it for a status conference at 9 o'clock on December 11th. Because of the separation of powers between the executive branch, who the state attorney, they are through that branch of government, and the judiciary, I can't tell the state, they have to give you an offer, they have to keep an offer open. So if the state says they're going to revoke it on that date, then that's traditionally what they do. So just be mindful of that. That's your homework. You know, determine whether you want to accept that offer or not. If you decide not to accept it, then we'll be looking at setting it for trial.
Okay. For the court's benefit, it would be a plea to counts 1 and 2 and dismissing counts 3 and 4 in exchange for that plea. But I'll discuss it again with Mr. Towery at the jail. I know his family will too. And then we'll have an answer from the court on December 11th.
Okay. I'll see you on December 11th.
Thanks, sir.
Thank you, sir. Okay, the other folks that are in the gallery?
I do not, Judge.
Ma'am?
It's Mr. Koch's parent.
Oh, gotcha, okay. Okay, we're in recess until 1:30. Thank you.
All rise, please.